Yes, please. May I pray for the listing of 4 petitions for motion, Your Lordship? The matter pertains to the petitioners have challenged the answer key of the APSC combined competitive exams. Similar matters are otherwise listed before Lordship today also. So today, tomorrow, whenever it is convenient for you. Not possible. Tomorrow, Your Lordship. Yes. Deeply okay.
Lordship, I wish to mention item number 27, Lordship, with the consent of the other side, Lordship. This matter may be listed after the vacation, Lordship. The conducting counsel, Mr. D.P. Bora, is not well, Lordship.
Yes, my lord, since my learned colleague is not well, I cannot object, but may I take for a date, my lord, some urgency after the vacation.
Miss A. Bora, Miss D. Bora, learned SC, Health Department, Assam, 6 adjournment of the admission hearing of this matter with the request to post this case again after the vacation. Mr. J. Patwari, learned counsel for the petitioners, is present and does not oppose the prayer. However, he prays for fixing a firm date after vacation. In view of the above and on the request of learned counsel for both the sides, this matter stands adjourned till 1st August 2023. Let this case be listed accordingly. Yes, yes.
May I please, Lordship? Lordship, I beg to mention for listing the motion matter, Lordship. The matter relates to the recruitment of the Central Armed Police Force, Lordship, for the petitioners was rejected due to height, Lordship. Similar matter listed, Lordship, tomorrow, Lordship. Tomorrow, most of this.
My lord, may I put for listing of a new matter for listing tomorrow, Your Lordship? Matter pertains to retrenchment of some employees of ASTC, Your Lordship. The similar matters are listed today, but it may be fixed tomorrow. Much obliged.
May it please, my lord, I beg to mention a matter for listing for tomorrow.
All matters are to be listed tomorrow only.
My lord, similar matters are coming up. Compassionate appointment cases, bunch of cases are coming up tomorrow.
It's listed today.
My lord, register it on 27th. My lord.
All right.
Highly obliged.
May I please, Lordship? Lordship, item number 21, my lord, with the concern other side, it may come up first week of August, my lord.
On the prayer of learned counsel for the petitioner made with the consent of the other side, this matter stands adjourned till 10th of August, 9th of August 2023.
Deputy.
May I please, Lordship? I beg to mention for listing a matter for motion of witnesses.
What is the matter?
Matter is like interview to be held on 1st of July. So my candidature was rejected. Obliged.
May it please, your Lordship, with due consent taking from the other side, item number 50, my lord. This matter may adjourn after
50.
50, my lord. My lord, interim order passed on 3/5/2023, my lord, may be continued.
Who's for the other side?
Other side, my lord, B. Gogoi, I have taken consent from the
This R.S. Devi, learned counsel for the lead petitioner, stroke applicant, 6 adjournment in this case with a prayer to post the matter again after vacation. Since the prayer is made with the consent of Mr. B. Gogoi, learned SC Finance, same stands alone. List again in the first week of August 2023. Interim order passed earlier to continue till then.
Obliged, my
Honor, I beg to mention for listing for an IA, filing number IA 7660/23 for auto correction.
When you want it, day after tomorrow.
Can it be listed on 28th?
28, yes.
Highly obliged. Your Honor, I'm standing for item number 28. My senior counsel is out of station, so Your Honor may kindly adjourn the matter for 2 weeks.
Have informed the other side
Yes.
with the consent of the opposite party. The petitioner's counsel prays for adjournment in this case for 2 weeks. Prayer allowed, let the matter be listed accordingly. Yes.
Nice.
May I please, Your Lordship? Lordship, I beg to mention one unlisted matter for listing. In this
Unlisted
matter,
matter for listing. Unlisted cannot be listed. Huh?
judgment file on 22nd June.
When,
This
when, you
matter,
want it?
Lordship,
When you want it?
on 30th June.
30th June. All right.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I may be allowed to withdraw the writ petition.
Which matter?
Uh,
Item number?
Item, it's not listed today.
All right, then let it come in the list. Then we'll do it.
Okay.
You want to mention for withdrawal?
Yes, Your Lordship.
Then give this to you. Yes.
Okay.
Day after tomorrow.
My lord, matter pertains to pay parity, my lord, otherwise. I am otherwise, my lord, prepared, my lord, so far as the industries department is concerned, he's on Lakes in court number 1. After some time, my lord, he will be here.
No, but petitioners
Otherwise, my lord,
counsel-
so far as the prayer is concerned, my lord, in the ROP 2017, that has been taken care of. They've been fighting since, my lord, 2010. But in, my lord, ROP 2017, it has been taken care of. They are getting the, my lord, same pay scale as on date.
All right, we'll call it up after some time.
Lots.
Yes.
May I please, your lordship, this is a covered case, lordship. Similar matter was disposed of by the honorable court, lordship. The petitioners were engaged by the hospital management committee, lordship. They have been working since last 10 years, more than last 10 years, lordship.
My lord, if this is their specific stand that, my lord, they have been engaged by the hospital management society. In that case, my lord, it is covered. They will have to submit their application claiming, my lord, minimum of the pay scale before that authority, not before the government. My lord. That may be clarified and I'm placing the order.
Let's see.
Take down heard, Mr.
Yes, Ali, lordship.
Excellent Learned Counsel for the writ petitioners. Also heard Mr. B. Gogoi, Learned SC from Health and Family Welfare Department, Assam. For the respond numbers,
My lord, here, my lord, she will say all the health departments.
for the official respondents. Full stop. The petitioners herein claim to have been engaged as casual workers by the respective hospital management committees, stroke societies who are functioning under the respondent authorities. Instead, according to the petitioners, they have been serving continuously for more than past 10 years. Instead, however, notwithstanding the same, the petitioners have been denied regularization in service or at least the benefit of minimum pay scale. Instead, by producing a copy of the judgment and order dated 10/11/2022 passed by the learned single judge in WP bracket C 7711 of 2016. Mr. Ali submits that the prayer of similarly situated workers, casual workers engaged by the hospital management committee have been accepted by this court, and orders have already been passed for extending the benefit of minimum pay scale. Therefore, this writ petition be disposed of in the line of the directions contained in the judgment and order dated 10/11/2022. First up, Mr. Gogoi, learned standing counsel for the health department, submits that if the petitioners had actually been engaged by the hospital management committee, then in that case, it is correct that their case is covered by the judgment and order dated 10/11/2022. However, they have to submit their applications with supporting documents before the respective hospital management committees, stroke societies, for doing the needful. After going through the judgment and order dated 10/11/2022, I find that that was also case where similarly situated employees of the hospital management society had approached this court by filing WPC number so and so, which was disposed of by the learned single judge with the following directions, para 23 to court folder. In view of the stand taken by learned counsel for both the parties, I am of the view that the matter can be disposed of by providing that similar consideration be
My lord, they will provide, my lord, submit individual application before the authority.
Lordship.
in case of petitioners, subject to the condition that they would submit individual applications with supporting documents before the concerned authorities within a period of 6 weeks from the date of receipt 6 weeks from today. Along with a copy of this order.
Lordship,
With the above observation, this writ petition stands before the
Lordship, para 21 to 23, Lordship, of the judgment and order of passed in WBC 11711, Lordship. Specifically, there are 3 months have been given to the
3
department.
months, 3 months.
3 months, Lordship.
So you submit within 6 months,
Yes.
6 weeks.
Lordship.
On receipt of such applications, the respondent,
We'll
the
consider.
concerned
that's the-
respondents will consider the same.
Right.
In the light of the judgment and order dated so and so, within 3 months thereafter.
that's it.
With the above observation, writ petition stands.
Oblige, Lordship. Left Lordship. Because in the instruction, you have to bring the instruction only.
Yes.
As for instruction, Malak, in the advertisement itself, there is a specifically mention. Page 18, relevant person is at serial number 14, Malak. The 170 CM for the candidate,
No, he says he is entitled to relaxation because his brother is working under the. Assam.
Malak, it is applicable compensatory ground only for the word, Malak, son and daughter of the retired Assam Rifles.
Where is the
Malak.
policy?
That is the stand, Malak.
No, you are saying this based on what? There must be some document.
But I have a son, it is written here, the relaxation is applicable only to the compensatory ground rally candidates only. And annex of 14 is treaty of the writ petition, serial number 3. It is
So
clearly
only
mentioned.
compassionate appointment.
My lord, that is second round of litigation, this one, my lord. Earlier, that one has already.
That's not relevant. I'm telling you, the instruction is the
My
relaxation.
lord, yes, sir, their relaxation in respect of recruitment also is applicable. Let them have to
Alright, we
produce the
issue
record,
notice,
my lord.
That's all, nothing more at this stage. Heard Mr. B. Sinha, Attorney Counsel appearing for the writ petitioner. Also heard Mr. UK Goswami, Attorney CGC appearing for the respondents. In terms of the order dated 19/6/2023, Mr. Goswami has obtained written instruction dated 20th of June 2023 and submits that the requirement of 170 cm height is provided in clause number 14 of the advertisement. And insofar as the claim of relaxation is concerned, such relaxation is applicable only in case of candidates appointed on compassionate ground. Therefore, the petitioner's case is not maintainable in law as well as facts and circumstances of the case. Mr. Sinha, however, prays for some time to find affidavit, additional affidavit disputing the said contention. In view of the above NRM 6 weeks, since Mr. Goswami will appear for all the respondents, no formal notice, extra copies, etc. Copy of the written instruction dated 23 June 2023. 23 June, yeah, not 20. We returned in the record.
My lord, the notice issued, my lord, dismissed.
Yes, notice. It should be dismissed, but we'll do it after.
No, because in earlier litigation, they have said that it is also applicable in the recruitment one, in earlier,
Therefore,
by filing an affidavit.
file additional affidavit.
Yes, madam. Obliging.
May it please your lordship. My lord, petitioner, my lord, was appointed as receptionist, my lord, at the Mary's Public School, my lord. On 1/8/2016, my lord, and successfully after serving for 2 years, my lord, he was terminated from service on 26/7/2018, my lord. Therefore, my lord, the industrial disputes raised, my lord, by the petitioner, my lord. Subsequently, my lord, the labor department has raised some issue, my lord, and has taken the matter to the labor court, my lord, for execution, my lord. Now, my lord, the labor court, my lord, for executing the issues, my lord. Although all those issues were found to be found, my lord, but no relief was adequate relief was
We'll
there.
issue notice at
My
the
lords.
Mr. S. Hawk, Learned Counsel for the petitioner, peruse the amendments leading the petition, assigning the judgment and order dated
23 to 2020.
23/2/2023, passed by the Learned Labor Court, Assam, Guwahati, in reference to case number 09/2019. The instant writ petition has been filed. Mr. Hawk submits that the learned labor court has failed to appreciate and adjudicate the reference in accordance with law. Mr. J.K. Goswami, learned
One and
Government
two.
Assam prays for some time to obtain
One and-
instruction. Issue notice returnable in 8 weeks. Since Mr. Goswami has appeared in accepted notice for respondent number 1, no
And
formal
two.
notice is required to be sent to the said respondent. The presiding officer of labor court has been included as respondent number 2. However, it has been time and again held that the presiding officer of the court from a tribunal need not be made a party so as to assent the order passed by it. As such, the name of the respondent number 2 is hereby struck off from the record, registered to make necessary endorsement. Petitioner takes steps for service of notice upon respondent number 3.
My-
By registered with AD.
Obliged.
May it please your lordship. The salary of the petitioner must stop without following the provision of 9 of Assam Civil Service Appeal Rules. And except 12 page 42.
Lordship, in 3 other similar matters, your lordship, the Court of Honorable Justice Arundev Chaudhary has stayed the impugn order, your lordship. The arising from the same order. However, liberty was granted to the authority, your lordship, to proceed as per law against the petitioners, your lordship.
What is the impugn order?
Impugn order is that
Page 42, and except 12.
otherwise they are irregularly appointed, your lordship, in 1999.
Where is the order by the Royal Civil Judge?
Annex is page 44. Annex of 14.
So stay of order means salary will have to be paid. That is not the minimum.
Yes, your lordship, but proceedings we can, liberty was granted in subsequent to orders, your lordship. I have a copy.
You want a stay of this order. What will happen
And
if it
stay
is
of the order. And the
Yes.
salary to be released.
That cannot be passed on the first day.
And stay of the order.
They say invalid appointments.
But the procedure was not followed.
All right, I heard Mr.
Temporary-
S. Govil, counsel for the petitioner, assailing the order dated 23/2023, issued by the Register of Cooperative Societies, Assam, Khanapara, based on which the payment of salary of the petitioner was stopped. The instant writ petition has been filed. Mr. Gugoi submits that similarly situated employees had earlier approached this court by challenging the order dated 23/2023, wherein this court has passed an interim order of stay suspending the operation of the notification dated 23/2023. And therefore, a similar order be passed in this case as well. Mr.
V. Rajkua, your
G.
lordship.
Rajkua, Learned
Corporation.
Standing Council Corporation Department, Assam is present and confirms that 3 other writ petitions with similar grievance is pending before this court, wherein an interim order is operative. The learned counsel for the parties have invited the attention of this court to the order dated 14/6/2023, passed in WPC number 3398/2023, whereby the learned civil judge has stayed the operation of the interim order dated 20. Interim order is 28/3 here.
There's a typical error. The order is 20.
28/3.
Precisely, Bracket was 303 stop 2023 has been stayed. In view of the above, NOM 6 weeks, notice of motion returnable on 25/7/2023. Since Mr. Rajkumar has appeared in accepted notice for respond numbers
1 to 5, your lordship.
1 to 5, no formal notice is required to be sent to the said respondents. Extra copy with the repetition, requisite in numbers will furnish to the learned standing council. Who's for 6 treasury? Mr. B. Gogoi, learned SC Finance Department, Assam has accepted notice for respond number 6. As such, no formal notice is required to be sent to the respondents. Extra copies, etc., etc. Heard on the prayer of interim relief, it is hereby provided that operation of the interim order passed in WPC, the interim order dated 14/6/2023, passed in WPC number 3398 of 2023, shall be operational in the present case as well. List this case again along with WPC number 3398 of 2023.
There are 2 other matters.
As
your
well
lordship.
as
I will provide the list, your
2
lordship.
other connected matters, that is WPC so and so and so and so. Okay.
May please, your lordship. Now, if your lordship would kindly come to the impugned order. Operative portion is at page 61. As regards to the placing the petitioner into the category for giving them a suitable economic package if they have not completed 10 years of service. Details have been collected and it appears that as of now, persons seeking identical prayer numbers to more than 800 individuals and total financial involvement in the event of enhancement of wages to those persons, including the present petitioner, would amount to approximately 21.85 crores. The present status of APDCL is such that company would not be able to bear such huge financial burden. It is pointed out, refers to Malad so and so. Moreover, there are more than 100 identically placed persons, and APDCL would not be in a position to single out the petitioners for granting special economic passage by ignoring the claims of the similar placed persons. Regarding order dated so and so, it is seen that government on its own volition has decided to grant higher wages to the contractual employees working under various. My lord, as long as the order stands, how such stand can be maintained, my lord?
Which order? Which order?
Yes.
You are challenging this order,
No,
page 61.
yes, yes. This has been passed pursuant to an order of this honorable court, my lord. My lord will kindly come to page number 50. This is the order. And the operative portion at paragraph 8, page 52. Accordingly, this petition stands disposed of, requiring respondents in the APDCL to examine the claim of the petitioner if the authorities, upon condoning the shortage of period of 2 months, consider him to be an employee who has served 10 years. The relief granted at para 10 of the order dated be given to the petitioners. And if the authorities, after examining, is of the view that period of 2 months cannot be condoned, the other relief provided in paragraph 10. My lord, first relief was regularization. Second relief was, my lord, in terms of the Utpal Das's judgment, minimum of the scale. And third was, my lord, some suitable economic package. Now, in terms of this order, they have passed that order, which is under challenge.
So we'll have to issue notice of this.
No, well, only thing is, well, how, yes, this is notice.
All right, I had Mr. Ken Chaudhary, learned senior counsel, edited by Ms. Kakoti, learned counsel for the petitioner. Also had Mr. KP Patel, learned SC, ACL, appearing for all the respondents. In this petition, the order dated 21/3/2023, passed by the managing director of APDCL. That is the respond number.
Respond number 2.
Respond number 2 has been put under challenge by the impugned order dated 21/3/2023. The respondent number 2 has rejected the prayer of the petitioner for granting minimum scale of pay stroke financial package in terms of the earlier order dated 25/10/2021 passed in WPC number 5532/5532/2021. Mr. Chaudhary submits that the stand of the authorities is not only wholly arbitrary, but is also in violation of the earlier direction issued by this court. Mr. Pathak Lanet, SC APDCL prays for some time to obtain instruction and file affidavit. NOM 8 weeks. Since Mr. Pathak is prepared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the petition is furnished to the learned counsel for the respondent so as to enable him to obtain instruction and file affidavit.
Deeply.
Item 6.
Right, please, Your Lordship. Lord, here it is, assistant professor of the medical college, gynecology department. There are two proceedings were drawn up against him. And the impugn order of dismissal is passed. Earlier, Your Lordship, the one disciplinary proceedings, Your Lordship has passed, should rule. Your Lordship will find that order at page 77. Yes. Second paragraph. Issue rule is returnable in 6 weeks. Now, here's an interesting point is involved, Miller. Two proceedings were drawn up, one for negligence of duty, another for insubordination. Okay. Now, in which proceeding impugn order is passed? Nothing is mentioned. That apart, Miller, suspension period, I was not paid subsistence allowance. I was asked to go to the Silchar Medical College. I gone, joined there. There is no provision for staying there. I verbally said principal. Principal also verbally, but then you can go Guwahati or wherever you like. Then we learned for practicing as a doctor, private practice. But the rule is when you receive non-practicing allowance, then only you cannot. But I never got non-practicing allowance. So that proceeding itself, not as against the non-existent. But anyway, your Lordship will ask them to. So at this stage, you want a rule to be issued here? Yes, my Lord, because the earlier proceeding, the rule was, and this should be attacked and hard to do.
Well,
Not mistaken, but and senior counsel listed by Mr. D.K. Bhattacharya, learned counsel for the writ petitioner, assailing the order dated 10/3/2023, by means of which the petitioner was dismissed from service. The instant writ petition has been filed. The learned senior counsel for the petitioner submits that another connected writ petition 3098 filed by the petitioner, namely WPC number 3098/2023, has been admitted by this court and is pending disposal. As such, both the matters be tied together. Mr. B. Gogoi, learned standing counsel held, as well as Mr. T.C. Chutia, learned government traditional senior government advocate Assam, are present and do not have any objection if the writ petition is admitted. In view of the above issue rule, returnable in 6 weeks, since Mr. Chutia has appeared and accepted notice for respondent number 1. And Mr. B. Gogoi
for 2, 3, and 4.
respondent numbers 2, 3, and 4. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned departmental counsel. Petitioner to take steps for service of notice upon respondent number 5 by registered post be ready. List this case along with WPC number so and so.
Item 7.
Please, Your Lordship. This is a covert case, my lord. The covert case, my lord.
Yes.
Only thing is that lordship, if vacancy exists, lordship, because they are now.
Petition
OBC
got
OBC
more
candidate.
mark than the unreserved candidate.
Let them consider and pass an order. We can't change the order now.
Lordship.
Mr. K.R. Patgiri and Mr. S.S. Roy, they are OBC category.
OBC, my lord.
How many petitioners?
One.
One, my lord.
One.
अच्छा, तो चलो। We'll say your submission, it may be difficult to accommodate the petitioner.
Lordship.
Dispose of.
Obliged.
May it please your lordship. My lord, petitioner before your lordship, my lord, he is working as a deputy ranger. And the draft petition list was prepared. In draft petition list, my name serial number 143. But in final petition list, it come down to 153. Without hearing me, my lord, I do not know how they came down, my lord, step down me, my lord. So against that, I filed this petition. Also, my lord, in the meantime, my lord, ranger promotion has been made, my lord. So I am eligible to get promotion to the my lord, post of ranger. So, but they have not considered because of the downgrading of my gradation, my lord. So they have not
Promotion already given.
already given. So, my lord, that this stage notice goes, my lord, and pendency is not bar to consider my case, my lord, for promotion.
Or Mr. T.J. Mohantola, Senior Counsel, assisted by Ms. P. Sharma, and Counsel for the petitioner. The petitioner is aggrieved by downgrading of his seniority position in the gradation list, as well as due to non-consideration of his case for promotion to the
Post of ranger.
post of ranger.
First ranger.
Mr. B. Chaudhary, Learner Standing Counsel, Forest Department, Assam, raised for some time to obtain action on the matter. NOM, Mr. Chaudhary has prepared and accepted notice on behalf of all the respondents. No formal notice. is required to be sent in this case, extra copies of the petition, requisite in numbers, be furnished to the learned departmental council within a week from today. It is made clear that pendency of this writ petition shall not be a bar for the respondents to redress the grievance of the petitioner in accordance with law is so addressed.
Deeply.
My lord, we could not adhere to your lordship's timeline. We have filed an affidavit in reply today. It is not yet in the record. My lord, I pray, my lord, that the matter may be taken up day after tomorrow.
Let it be taken up on 30th.
30th, my lord, I will not be available, my lord, out of station.
On 28th, Lord.
Mr. B.D. Kaur, learned senior counsel appearing for the writ petitioner association submits that the rejoinder affidavit filed on behalf of his client this morning is not on record. Therefore, this matter be posted for motion again on 28/6/2023 by taking the rejoinder affidavit with the record of this case. Mr. P. Nayak, learned counsel for the respondents, is present and does not have any objection. In view of the above, register to tag the rejoinder affidavit and post the matter for motion again on 28/6/2023. You are appearing in which case?
57, my lords. There is an interim order which is till the returnable date. They are yet to file their
It's
counter.
connected
My lords, connected.
along with item 57.
This, my lord, they are yet to file the.
Lordship, we are filing our affidavit today itself. Lord.
Item
Some time to
57,
file.
right, had Mr. P. K. Goswami, learned senior counsel, assisted by Mr. Sosa, learned counsel for the petitioner. Also has heard Mr. P. Nayak, learned.
Lordship, learned advocate general is appearing, Lordship. He is online. Lordship.
Also heard Mr.
I am also appearing.
P. Saika, learned advocate general Assam, appearing for the state, who seeks 2 days time for bringing on record the counter affidavit.
Lordship, we are filing it today itself. Lordship.
Who submits that counter on affidavit on behalf of the respondents would be filed during the course of the day. As such, this case again on 28/6/2023 by tagging the counter affidavit, if any, filed by the respondents in this case. In place of asked earlier to continue till then. Yes,
Liberty to file rejoinder.
that is always there.
Always.
Deeply obliged, Lordship.
Yes.
Obliged.
When you write hard, Mr. D. Satyam, and then AGS report.
May I please, Lordship? My lord, in this case, my lord, instruction was called for. My lord, issue is, my lord, after issuance of my lord the appointment order, I have not been allowed to join. Page 37, my lord, pennies.
So who is the health council here? Standing council health? Nobody, Mr. Gogoi, you are no longer in health. Huh? Just a minute. What is the matter?
My lord, pennies, page 37, man. Annexure I, man. My lord, after duly selection of the
58 and 59, are you appearing, Mr. Gogoi?
Yes.
What happened?
Well, actually, the woman was supposed to appear. My lord, he was holding the brief.
But these are your internal matters.
Yes. Otherwise, my lord, recruitment, my lord, will issue notice in that case. My lord. Or after some time, my lord, let me have a look at it.
You have been appointed.
yes, ma'am.
Where is the appointment order?
37, ma'am. Page 30, you can see. I was supposed to join my lord on from 1st June. Last number kindly see my lord terms and condition 8.
So an order of appointment has been issued, then why is it not being?
My lord, in fact, my lord, this exercise has been carried out not only in the health department, but my lord, in the education department also, my lord, in the new recruitment process. My lord, what we have found is that, my lord, they come up with these certificates from the district authorities, showing that, my lord, they are above 40% disability, where otherwise they are entitled as per the act. Now, my lord, when this committee was constituted, when they were examined, it has been found that, my lord, all are, my lord, below, my few are below 40%. So, my lord,
So what is the,
considering
what is
this-
the case of the petitioner?
in the case of the petitioner, my lord, that I can have the instruction, it will be below, my lord, 40%. Because lordship will see page 38. Not only the.
So
only
we'll
the-
have it on 30th then.
Yes, my
Then
lord. I can
interim
place it,
order
my
will
lord.
be considered.
I will place the report of the medical board. What is
Alright.
his
Or
percentage?
Mr. R.S. Chauhan, counsel for the writ petitioner. In both the writ petitions, also heard Mr. B. Gogoi, Leonard SC, Health Department, Assam, who submits that he will granted time till 30th of June 2023 to produce the report of both the petitioners
Lord.
on the observations made by the medical board constituted for the purpose. On the request of Mr. Gogoi, these matters are being posted again on 30th of June 2023 on the next date fixed, depending on the instruction obtained by the learned departmental council. Prayer for interim relief will be considered. Yes, Mr. Chaudhary.
Make this. I'm a peon, my lord, serving at in the district consumer redressal forum, Nalbari. And there is no order by this honorable court, my lord, earlier, that a revised space would be granted, my lord. See, I am deprived of since 1996. And last order, your lordship, may kindly see at page 36, annexes 7. I have to come for implementation of the order, since it was not implemented.
May it please your lordship, before my learned senior start, my lord, on last occasion, this honorable court has directed the petitioner council to produce honorable apex court judgment. How this state could implement their
Yes.
order, my lord,
I have brought it. You lordship, may please.
because they did not file any contempt case, my lord, in this matter, and this is a third round of litigation for the same prayer.
Madam,
This is the maintenance.
First order that was upheld by the division bench. And thereafter SLP was filed, SLP was dismissed. Madam, in this case, madam, the apex court has said, madam, if court cannot exercise power so far implementation of the earlier order, then there will be end of the rule of law, madam. Yeah, I have, madam,
Yes.
I,
Yes, please.
madam, the factual part, madam, in paragraph 1 and 6, it has been stated. That
Actually, this has come for motion.
motion, madam,
This matter, you have to file your affidavit.
Lordship,
yes, madam.
Today, we can't pass a final judgment here.
lordship, this is the third round of litigation, I think, for same prayer.
Yes,
That's why I
then,
have
madam, that,
raised the question
since-
of maintainability.
Since I have not filed contempt application.
My lord, lordship.
I heard Mr. D. Chaudhary and counsel for the writ petitioner. There is the amendments made in the writ petition. The petitioner is aggrieved by non-implementation of the ROP rules of 1998 in his case. In his case, despite the earlier orders passed by this court. Ms. M.D. Bora, learned government advocate Assam, has questioned the maintainability of the writ petition by arguing that this being the third round of litigation with the same prayer, the petition is not maintainable in law. The learned government advocate, however, prays for some time to file affidavit assailing the maintainability of assailing the writ petition on the point of maintainability. First up, NOM 6 weeks since Ms. Bora appears and accepts notice for all the respondents. No form.
1 and 3, my lord.
1 and 3. What about 2?
2 is the lordship notice may go, the president, district consumer.
As such,
district
no formal notice is required to send to the suit respondent,
And 4 is the finance department.
petitioner to take steps for service of notice on respond numbers 2 and 4. Oh no, Mr. B. Gogoi, learned SC Finance Department, Assam accepts notice for respond number 4. As such, no formal notice is required to be sent. To the respond number 1, 3, and 4. Extra copies of the repetition will furnish to the learned department council. Petitioner to take steps for service of notice upon respond number 2 by registered post to AD. Question.
I will be allowed to serve by hand also, my lord.
In addition, the petitioner is also granted leave to make justice service of notice upon the respond number 2 to be routed through the registry of this court. The question of maintainability of the petition is kept open and shall be gone into at the stage of admission.
I'm deeply obliged, my lord.
The date may be fixed, my lord. I am deprived of the revised pay, my lord, since 1996, my lord.
You come in August, what is there
Yes.
to do? Date? If every case you ask for date, then all dates will become meaningless. So therefore, this case again in the second week of August 2021.
Obliged, my lord.
Yes. See, Mr. Das and Mr. Mahanta, the orders passed by the court are usually to be, and correctly so, to be treated as continuous orders, regardless of the bench which has passed the order. But in this case, it appears that the learned judge has taken a particular recourse, which I may not be inclined to take. So therefore, what is to be done? Either the matter has to go before the same judge.
Because
Otherwise-
prima facie, I am not
Otherwise,
satisfied that what is
we'll
there.
take a turn.
My lord,
I will not go into the question of academic background of the petitioners to
it is-
adjudicate whether they are eligible to participate in the mains exam or not. This issue, according to me, or this court will be
nothing.
entirely confined to what has happened in the prelims exam. But then the learned judge has taken a recourse.
Lord, that
You
is-
have to say that you give it up. Otherwise, the matter has to go before the same bench. There is no
I
third
understand.
option.
Lord, what I have understood from the last order passed, my lord, what happened on the last occasion? Item number 61 and 63, this honorable court heard. 61, my lord, because lordship will appreciate, in all the cases, my lord, the questions are different. Item number 61, my lord, there were some questions which I placed before your lordship, this honorable court, and this honorable court expressed the view. But that view is tentative because of the fact the court wanted to examine the academics, my lord. That I leave it to.
No, Mr. Das, perhaps you have not followed what the court
I'm
is
sorry.
saying. There is a common order passed in all the three writ petitions.
I have seen, my lord.
There, the learned judges asked materials to be placed to examine the academic competence
Yes,
of the petitioners.
true.
I am not inclined to take that course.
Then your lordship,
Therefore, either you
consider-
say that you give up that you don't want any such.
I don't want, my lord. I, in my pleadings also, I don't have any academics, reflection of academics. My question is not that. My only, my lord, ground is that, my lord, there are questions which, as per the petitioners, my lord, those answer keys are wrong. Those answer keys are to be corrected, my lord. They fail to correct it. That is my simple case before your lordship, my lord. Nothing more than that.
That is not.
Lordship will consider the questions. Lordship will consider the questions. If your lordship finds that yes, prima facie, there are doubts, lordship will take a call thereafter.
We'll take up the matter tomorrow at 2. All these cases along with the other matter coming.
Other matters.
We'll take it up for, there is some mention has been made today.
Lots
for a similar matter.
Lordship.
We'll take up these cases for disposal tomorrow. Please come prepared.
My lord.
Tomorrow at 2.
Two.
Mr. H.K. Das, Learned Counsel for the. Tomorrow as last item of admission.
Yeah, absolutely fine with it, my lord, no problem.
Also heard Mr. T.J. Monto, Learned Senior Counsel. Assisted by Ms. So-and-so appearing for the APC. This morning, mention for listing of similar matters filed before this court today have been made with a request to post the case again tomorrow, which prayer was allowed by this court. As such, these writ petitions are directed to be listed tomorrow as fixed items for motion. These cases shall be taken along with the connected matters immediately after the admission matters are over.
Deeply.
Kindly record top of the list. Item 55.
So ROP rules 2017, your grievance has been redressed. I will close it then.
Lordship, with regard to 2000, Lordship, we are claiming for the part under the 6 CPC as well, Lordship, because
Huh?
Lordship, under the 6 CPC, Lordship, that was not given to us. Subsequently, under 2017, under the
You
7.
make a representation. 6
Lordship.
CPC is after the filing of your writ petition. How can you get a relief about something which was not even there?
It was not
No,
there,
it
Lordship.
was prior to the
Writ petition.
There is nothing in the prayer, Lordship, you can see the prayer purpose. There is no prayer that they must get in my.
All right, heard Mr. H. Chakraborty,
Two
learned
prayers.
counsel appearing for the writ petition. I also heard Mr. B. Gogoi, learned SC Finance. I also heard Mr. A. Kalita, learned Standing Counsel, Industries Department, Assam, appearing for respond numbers. Respond numbers,
Respondent number 3 and 4 years. Sorry, Lordship. 1 and 2, Lordship.
respond numbers 1 and 2, and
3 and
Mr.
4
B.
have
Gogoi,
Three and
learned SC Finance for respond numbers 3 and 4. Full stop. The writ petitioners herein are all employees under the Industries Department of the Government of Assam. By filing this writ petition, they have approached this court seeking a direction upon the authorities to revise their pay scale by giving effect to the revise their pay scale in the pay band 3 with grade pay of rupees 4,300. Mr. Gogoi submits that the relief sought by the petitioner has already been given to them under the ROP revision of pay rules of 2017, and therefore nothing survives for adjudication in this case. Mr. Chakraborty has fairly admitted that his clients have got the relief under the ROP rules of 2017, but he submits that the benefit of the 6th CPC have not been given to them till today. Full stop. I find from a perusal of the pleadings in the writ petition that no grievance has been expressed in the writ petition pertaining to 6 CPC. Therefore, the said aspect of the matter cannot be adjudicated in this writ petition. As such, by taking note of the submissions of learned counsel for both the parties and by granting liberty to the petitioner to agitate their grievance, if any, pertaining to 6th CPC, this matter stands closed.
Lordship, one clarification, Lordship. They have 2 prayers, Lordship. Out there, Lordship may kindly see that page 18. Page 18, the prayers 1 and 2, Lordship. So 2 basically they wanted that parity. Prayer number 2, they wanted the parity with the pay scale also. So that has been allowed. Now, as far as Lordship, prayer number 1 is concerned, what they were seeking is like they wanted parity with some other departments, extension officers of agriculture department and fisheries department. That cannot be allowed in this petition.
This writ petition has been filed by the petitioners who are employees of the industries department with the following prayers. Page 18 of the book. So and so submits that the grievance of the petitioner insofar as the claim for parity of pay is concerned has been redressed under the ROP rules of 2017. First up. Tabisab taken 6 CPC.
Lords, publish.
By now, most of them have retired as well. By now, most of the petitioners have retired.
All right, so if they're retired, they're retired.
Obliged.
Order stay vacating item 9.
Proceed in this case, your lordship, we will need some time to file an objection to the.
Yeah, for whom?
I am for the writ petitioner.
Read petition.
Yes, what do you say?
Lordship,
Had Mr. M.K. Hussain, learned counsel for the applicant, also had Mr. S. Bhattakur, learned counsel for the writ petitioner stroke OP. He prays for 2 weeks further time to file objection, 2 weeks time to file objection. Prayer allowed, Mr. G. Bodole, learned SC Corporation Department Assam is present on behalf of the respond number.
One.
Who is present on behalf of the OP number.
Number 2, 3.
Respond number 2, 3, 4. OP number 2, 3, and 4, and Mr. Respondent number 4.
5.
And Mr. As thus, learned counsel is present on behalf of the OP number 5. This is the matter after 2 weeks.
Lords, date may be fixed, lordship.
After 2 weeks, you count, it will come.
All right.
Interim order passed earlier. This is an interim order.
Lordship.
Interim order passed earlier to continue until further order.
Lords.
May I please, your lordship?
Yes.
For implement of new incumbent, my lord, who has joined as chief engineer, public health engineering department. My lord. That's respondent number
Yeah,
3.
for whom?
I am for respondent number 2, my lord. My lord, I have got instruction. No, my lord. But in fact, if your lordship permit, my lord, the secretary has not been made a party, my lord. The issue in this case, the main decision would be taken by the secretary, my lord. Because it's a sanction of the my lord, post. But we have done our bit, my lord, but
Let them file their affidavit, my lord. I will try it, my lord.
Then you will again implead.
My lord.
You will again implead thereafter.
My lord, order is there, my lord. Honorable court, my lord. So, my lord, at this stage, my
The
lord,
creation of post without secretary, I can close it today itself. It is not maintainable.
actually, my lord, after forwarding
All right,
the
I have
order.
Mr. J. Sharma, learned counsel for the applicant, is IA has been filed with a prayer to implead the new incumbent in the post of chief engineer, public health engineering department, Anganwadi, on the ground that he is now responsible for implementation of the court's order. Mr. R. Dubey, learned counsel for the respond number 2 is present and submits that the secretary of the department is not a party in this case, and therefore the contempt case is not maintainable. Be that as it may, taking note of the prayer made in the IA and the ground stated therein, the prayer for impleadment stands allowed. Mr. So-and-so, that is the incumbent secretary in the post of Mr. Who is it? Dibjyoti
Depository Dwara.
incumbent chief engineer in the post of the incumbent in the post of chief engineer PhD department Assam is hereby included as respond number 3 in the connected contempt case, registered to make necessary endorsement in the cost title highest and disposal.
Obliged, please.
For admission, I can clear the.
Maybe lordship. And in this cases, my lord, they produce my lord Supreme Court order, my lord. So we need some time, my lord. We will differentiate.
Lordship, already Supreme Court has allowed our petition, lordship. So similar matters, lordship. We have submitted the judgment, lordship.
What is the matter about?
Constable GD recruitment, my lord. Question regarding my lord preference, my lord. Suppose I opted my lord preference A, my lord. So my case is there. I can be considered against preference B or C, my lord, in any preference, my lord. If I got the marks, my lord. Secondly, my lord, there are available vacancies out of 63,000 vacancies. So after
Supreme Court has decided this matter.
yes.
We
will
post it
differentiate
for dismissal after vacation. On the prayer of Mr. So-and-so, learned counsel for the petitioners, these matters will be listed again in the
Yes,
first week of August 2023 for dismissal. Is it or admission? Hearing Mr. S. Roy, S.S. Roy, learned CGC, as well as Mr. C.K.S. Borua, learned CGC, appearing for the respondents in this batch of cases. have submitted that the issue is covered under the recent judgment of the Supreme Court rendered in the case of
Civil appeal number 11441 of 2022.
rendered in civil appeal number
1441,
1441.
14412, 1442 of 2022.
1441 to 2020. 2020.
22.
This is the matters accordingly.
Please, Your Lordship. Matter pertains to reservation in promotion for physically handicapped disabled persons. Lordship will kindly peruse the order dated 10/2/23. Certain queries were raised by the Honorable Court and they were directed to file an affidavit as regards the promotions in the made so far in the disabled quota. They have filed an affidavit. I do not know whether it's on record or not, but the queries raised by the Honorable Courts does not seem to have been addressed by the department in the affidavit.
In this case, Lordship, the learned senior government advocate will address, Lordship, can pass over to me.
Let him address. We are passing orders now.
Lordship will kindly.
Don't ask the court to wait for any advocate. We are not going to do it. Who is senior advocate, who is not, we are not concerned. When the matters are called up, whoever is present will hear. Where is
And
the
the affidavit they have filed pursuant to the Honorable Court's order.
Affidavit filed on?
Affidavit they have filed on, we received it on 11th of April. 11 April, no? Serial number, pagination is, say, starting from 68. Affidavit 68.
So they have answered. Why do you say in para 3? The answer has
Lordship,
been given?
paragraph 2, the query was how many vacancies in the promotional quota pertaining to assistant engineers has been filled up by promoting candidate belonging to PWD category. They say that total of 8 numbers of junior engineers belonging to PWD category have been promoted to the cadre of assistant engineer. Lordship, promoting persons belonging to the PWD category in the merit and promoting them against the quota is a different matter altogether. This is, and the records show that the
No, out of 8, 2 are from PWD quota. That's what they say. Not merit. Quota, PWD quota doesn't mean merit.
No, Lordship, the persons, I have the, Lordship, the data, we have even enclosed them in the IAS which we have filed. There were 2 batch of promotions carried out during the pendency of the present
So,
petition.
have you filed any rejoinder against this?
We have not filed a rejoinder, but the answer, apparently the answer that is provided by them in the affidavit does not reflect that the 8 persons which whom.
Achha, we'll come to that. So you don't want to file any rejoinder. If you don't want to file, then we'll move on to the next stage. It can't be that after hearing suddenly you say, I want to file rejoinder.
Then Lordship, I'll enclose the data and file a rejoinder.
It is up to you.
Yes,
Up to you.
Lordship. Lordship will grant.
If you want to file, then what is the point in hearing on this text today? If you don't want to file, then we'll go at the hearing. But if we, after hearing, we'll not give you time to file.
Because Lordship, the apparently.
Ms. Borgohai, you understand simple English. Do you want to go ahead with the hearing today or you want to file rejoinder?
Then Lordship, I'll file a rejoinder and
Then
closing
up to
the
you.
complete data. Yes,
You make
Yes.
that request, we'll adjourn it. How
Lordship.
much time you want?
After the vacations.
She wants to file a rejoinder, short rejoinder. Ms. D. Borgohai, Learned Counsel for the writ petitioners, submits that 2 weeks time be granted so as to enable her to file a short rejoinder responding to the responding to the affidavit filed by the respondent number 1 on 12/4/2023. Mr. D. Nath, learned senior government advocate Assam, is present on behalf of the respondents and does not have any objection with the prayer is allowed. In view of the above, let these matters be listed again after the rejoinder is brought on record by the petitioners. You complete your pleading and then we'll take up the matter for final disposal. What else is there?
Yeah, please, your lordship. Lordship, kindly may allow for time being, lordship. My senior is Legon in court number 11, lordship.
No, matter has to come possibly, my lord, before the appropriate court, Michael, my lord, this is Michael Japan form, my lord.
Why?
Division bench order is there, my lord. His case was, my lord, petition file. Petition, my petition was allowed, review file that was dismissed, appeal file, appeal that order was passed. Last bab ever applied.
So now review petition has also been revived.
Review petition, my lord. The review petition, my lord, was dismissed. The opposite party filed, my lord, subsequently filed writ appeal. In that writ appeal, my lord, cost was directed to pay to me, my lord.
Mr. H. Das, learned counsel, H.K. Das, learned counsel for the
Writ petitioner.
H. Das, learned counsel for the writ petitioner has produced a copy of the order dated 15/12/2022, passed by the division bench in writ appeal number 371/2022 to submit that. Since the division bench has set aside the order dated 16/11/2022, passed in review petition number 169/2022 and remanded the writ petition for being heard by the learned single judge afresh on merit. Hence, this matter is required to be listed before the appropriate bench. Bracket, Michael Jotan Kumar Jai. The learned counsel for the respondents has also supported the said contention. I have perused the order dated 15/12/2022 and find that there is reasonable ground for the petitioner's counsel to make such a prayer. Registry to therefore verify and list the matter before the appropriate bench.
Obliged.
Item 19.
Lordship, this is direct harness case, my lord. On last occasion, my lord, respondent number 1 and 4 sought time to file affidavit in opposition as the last chance, my lord. But today, I think they are not able to file affidavit in opposition.
Here in this case, Lordship, the rejection order was passed by the state level committee for compassionate appointment, Lordship. But state level committee is not made party, Lordship, here in this case. No, state level, it is.
Forget all these things. What is your stand on merit?
Lordship, the petitioner, my lord, wife of the deceased, my lord, who deceased expired on demise on 29 to 2016, my lord. That is page 24. He was a master worker under 4th grade, my lord, and under respondent number 3, my lord. Now, my lord, thereafter, my lord, within the stipulated time on 23/9/2016, made a representation on format, my lord, on compensation ground. That is page 25. Now, my lord, district level scrutiny committee allowed, my lord, but state level committee, that is.
So what is the ground of rejection? Where is the order?
Rejection saying that one person, that is Said Inamul Ahmed, also filed application, and thereafter my application was filed. That is after, use after Said Inamul Ahmed for single
Which
admission.
page? Which page?
Page, my lord, 30, my lord.
Serial number 15.
And petitioner name shown under serial number 15, Srimati Jayanti Medi, and reason ground of rejection shown applied after Soed Inamul.
So
Ahmed.
one post available, 2 persons applied, one who applied earlier.
But question is after, because my husband expired after later on, therefore I file application later on. But it cannot be ground that I am not entitled to get the
Of course, if
benefit.
there is one vacancy and 2 persons apply.
And my lord, subsequently, I think
will be the ground.
if vacancy arise already, if that there has not stated whether presently.
Who is the person to come to the court? Give me his name. Let him come personally. We are directing personal appearance.
No, state level committee is not the party.
No,
here.
not required.
Required.
Not required.
Respondent 1 is
Then
sufficient.
let the chief secretary come.
That's, he is not the party here in this case. Lordship.
Others are parties.
Lordship, he may get some opportunity to reply.
Secretary.
You have not implemented the.
Yes,
state
Lordship,
level
yes, Lordship.
committee.
Chief
No,
secretary is
but
not.
I have mentioned only secretary, my lord.
Secretary is secretary PWD department. Lordship.
Your grievances against the SLC.
Yes, Lordship.
Heard Mr. K. Learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respondents. Respondents numbers 1 to 4. You have for 1 to 4 or?
Lordship, I am only 4, Lordship.
For respondent number 4. Mr. Who is for the PWD?
PWD.
Mr. R. Dhar, learned SC PWD Assam has appeared for respondent numbers 1, 2, and 3. The petitioner is aggrieved by the rejection of our candidature for appointment on compassionate ground by the SLC. Mr. Goswami, learned government advocate Assam, however, submits that the SLC, the chairman of the SLC is not a party to this writ petition. Could be that as it may, after going through the statements made in the petition, I am of the opinion that the chairman of the state level committee, Dispur, Assam, is required to be included as respondent number 5 in the writ petition, ordered accordingly, the registry to make the necessary endorsement in the cost title. Oh, you can't do it now. You have to file amended petition.
Yes.
Now.
For implement. Or we can.
Amended petition. Amended cost title. Registry to nalage. Petitioner to file amended cost title by showing the newly included respondent as respondent number 5.
As chief secretary only. Only chief secretary.
Chief secretary, chairman state level
committee, namely the chief secretary Assam. Let this matter be listed again after the amended cost title is filed. Mr. Goswami accepts notice for the newly included respondent number 5. No formal notice is required to be sent to the same respondent. 6 weeks time is granted to the learned government advocate Assam to obtain instruction file application. Next recording. You are for whom?
Respondent 1 to 3.
Ardhar on behalf of Ardhar.
Or lordship, one order be passed that till pendency of this petition. If vacancy is there, that should be kept.
No, nothing comes apart.
Obvious lordship.
Item 20.
In this matter, my lord, today they have filed an affidavit reply. Reading is completed, my lord. Maybe please for hearing.
Miss,
IRS, your lordship, on behalf of IRP.
the council is present on behalf of petitioner. Mr. T.C. Chutia, learned additional senior government advocate Assam submit that copy of the affidavit in reply has been received by him this morning. And therefore, this matter be posted for admission hearing in the first week of August by tagging the affidavit in reply. They are allowed register to list the matter accordingly.
Obliged.
Item 22.
May it please your lordship, my lord, pleading counted, my lord, matter on the posta immediately after vacation for final disposal.
It is submitted at the bar that this matter is ready as regards pleadings and can be taken up for disposal at this stage of admission hearing. In view of the above, register to list this case after vacation, after summer.
Lordship, date may be fixed, sir.
In the column of disposal at this stage of admission hearing, unquote, on a non-miscellaneous day.
I am deeply obliged.
Item 23.
May please, Lord. This is a matter regarding payment of the pay scale, my lord. Because though they have given the benefit up to 2015, my lord. Actually, I was entitled for 1/10/2005, my lord. The petitioner, my lord, he was initially appointed as a copies, my lord. Revenue copies, my lord. That your lordship will find.
Affidavit exchange, pleadings exchange.
Yes, links are exchanged, my lord.
Then who's for the respondents?
The respondents, my lord, the state of Assam, my lord, represented by Commissioner Secretary, Registered Revenue Registered Department, my lord, and finance as well as.
So what is to be done? This is to be fixed for admission or today?
Actually, this one hearing, my lord, can be disposed of. If lordship,
When?
as your lordship's convenience, my lord.
Are you ready today? Huh?
After vacation also.
Vacation fever has started.
Yeah, already is in mood of vacation.
Mr. P. Kotabil, counsel for the petitioner, also had Mr. J. K. Goswami, landed additional senior government advocate Assam, as well as Mr. J. Henry, landed standing counsel, Revenue Department Assam, appearing for the respondents. It is submitted at the bar rights in second week of August.
Second week of August.
August, in the column of disposal at the stage of admission.
Because he has not drawn pension as yet, my lord. He's waiting for the scale, my lord.
Yes.
Item 24.
24. Yes, okay.
Lordship, here in this matter, we have filed an additional affidavit on behalf of the respondent number 4 this morning, Lordship. We have served a copy, Lordship. Let it come.
Mr. A. Sharma, learned counsel for the petitioner, submits that he has received a copy of the additional affidavit filed on behalf of the respondent number 4 only this morning, and therefore be granted 2 weeks time to file rejoinder. Mr. D. Upamendu, learned standing counsel, Health Department, Assam, is present on behalf of the official respondents. On the request of Mr. Sharma, let this matter be listed again after the summer vacation. In the meantime, rejoinder, if any, be brought on record by the petitioner. Yes, sir.
Highly obliged.
Lordship, here in this case, Lordship, I have to file another affidavit on behalf of respondent 4, Lordship. Other respondent we file, Lordship. Respondent 4, Lordship, needs an affidavit, Lordship. Kindly fix the matter immediately after vacation, Lordship. I will file the
Mr. T.
affidavit.
W. learned counsel for the petitioner is present. Mr. J. K. Goswami, learned counsel appearing for the respondent number 4. Prays for one final opportunity to file affidavit on behalf of this client with a request to post the matter again after the summer vacation. Mr.
And Kalita.
N. Kalita, learned counsel is present on behalf of
One.
respondent number 1. And who is for 2 and 3?
Yes, me also. I am.
Uh,
I am.
And the learned government advocate appears for respondent numbers 2 and 3. On the request of Mr. Goswami, she whose further time is granted as last chance to be respondent number 4 for filing affidavit. Accordingly, this matter be posted again on 7th of August 2023 as a fixed item. 7th August 2023.
Can it be beat early, your lordship?
Yes.
And it's all 7 August.
It can be on 4th August.
Your lordship.
Which do you want?
7 August. Your lordship. Leave your lordship.
Yeah, yes, for the petitioner on call. Use this case again after the vacation, after the summer vacation.
May it please your lordship, on last occasion, lordship has directed the SC irrigation to obtain instruction, my lord.
Yes,
My lord, I will allow other type to obtain instruction.
DLC forwarded our case, my lord, but SLC not yet considered mine. This is simple case, my lord.
In fact, lordship, I have received one letter which shows that the executive engineer has written to the additional deputy commissioner and he reported that he has forwarded the DLC minutes to the secretary irrigation to take appropriate decision, but yet to take any decision. Second last paragraph, my lord. The paragraph was reply, my lord.
yes, so what action has been taken? You have to say, you are representing the deputy commissioner.
My lord, we have, DLC has recommended his name and the executive engineer irrigation department has forwarded his proposal to the secretary, the higher authority. Then they have to place it before the SLC, if not yet placed, my lord. Their standing council is here, irrigation department.
Yes,
Lordship may dispose of this matter also.
their case will be considered in the next SLC.
SLC, if not placed earlier, if placed, the outcome may be communicated to the petitioner.
Okay.
Is placed by the secretary irrigation.
Council for the petitioners. Also heard Miss MD Bora, learned government advocate Assam appearing for the respondent numbers
2 and 4, my lord.
2 and 4. Miss DS Nyog, learned standing council irrigation department Assam is present on behalf of respondent numbers 1 and 3. Full stop. The how many of them want compassionate appointment? All of them.
My lord.
Is it permissible? Only one will get compassionate appointment.
Yes, it's,
All are come under compassionate quota, my lord.
but combined petition cannot be.
Excuse me.
This is same.
All of them want job. The writ petitioners herein are seeking appointment on compassionate grounds due to the premature demise of their father, who died in harness on
Page number 4, my lord. Second, third and fourth.
When did he die?
My lord, 26/1/2009, my lord, the father of the petition number 1. And father of the petition number 2, my lord, 18/2/2014. And
Lordship,
died
what
in
is
August.
in page 11, my lord, DLC
The
minor.
father of the petitioner 1. Namely. Late Hamchandra Bhakti, BAKTI, died on
26/1/2009.
2009, and his application seeking appointment on compassionate ground was made on 27/2010. 20, then 7, then 2010. The father of the petitioner number 2, late Vasudev Burman, died in harness on 18/2/2014, and he had submitted his application seeking appointment on compassionate ground on 26/5/2014. Full stop. Likewise, the father of the petitioner number 3, namely late Rafiquddin Barbuya, died in harness on 18/8/2013, and thereafter he had submitted his application seeking appointment on compassionate ground on 11/11/2023. Full stop. The case of the writ petitioners is that although the DLC Kachar had recommended their case for appointment on compassionate ground by resolution adopted in his meeting dated 2/2/2023, no action has been taken by the state level committee SLC to consider their case. Full stop. Ms. Bora Learned, Government Advocate Assam, submits that the matter has already been processed at the departmental level and necessary communication has been sent to the Secretary of the Irrigation Department Assam to take steps for placing the case of the petitioners before the SLC. Therefore, she would have no objection if the petition is disposed of by issuing appropriate direction. Similar is the stand of Ms. D.S. Nyog, Learned, Standing Council, Irrigation Department Assembly. In view of the above, without commenting on the merit of the claim made by the respective petitioners, it is hereby provided that the recommendations made in favor of the DLC in favor of all the 3 petitioners shall be placed before the next meeting of the SLC, if not already done, for taking appropriate decision in the matter as per the existing norms and government circulars. Full stop. If the petitioners' cases have already been considered by the SLC before passing of this order, the result thereof be intimated to them in writing.
My lord.
With the above observation, the writ petition stands closed.
Lordship has specifically directed the Secretary Irrigation to place the matter before SLC. They have to.
If the matter be considered by SLC, Secretary Irrigation Department, Assam, to do the needful.
My lord, I'm deeply obliged.
Obliged.
In this matter, my lord, so we are directed to, my lord, bring on the record the instruction received by us, my lord. Accordingly, we have filed an affidavit annexing all these things, my lord. As per our affidavit, my lord, instruction also, my lord, petitioner was appointed temporarily without any selection. That was upgradation to the, as a helper, to the upgradation to the worker, my lord, they cannot approve it. Director has passed this order, we cannot approve it because she was not legally appointed. That is the case. Appointment letter is annexed here, my lord. Page 25.
Page 25.
Page 25.
Just a minute.
Our affidavit.
Mhm.
12 July 2010.
Just 1 minute. So what do you have to say, Mr. Alamgir?
Lordship, kindly in my petition, page 10, Lordship, advertisement profits.
Yes.
Eligibility criteria, the applicant must have minimum 10 years working experience as Anganwadi helper. Eligibility criteria, 1, Lordship.
Yes,
So,
but
Lordship,
that experience has to be on the basis of a valid order of appointment.
That is
the
the
question is that, Lordship, it is experience 10 years. I have 12 years experience, Lordship.
Where is the order of appointment?
Appointment is, Lordship,
it's a B.
page 11, Lordship.
Page 11.
Lordship.
Subject to approval from the competent authority, you are hereby allowed to render voluntary service temporarily as Anganwadi helpers for a period of 3 months. So that was not that was subject to approval. That approval was never given by the director. So you have entry to the service is not legal, my lord. Without any approval of the director, CDPO engaged her. Now she has come for upgradation of Anganwadi worker.
It is 3 months, Lordship, but I am still working. Not only as a helper, also as Anganwadi worker, Lordship. I am imparting my duty. Still 1 year, Anganwadi helper worker is not there, Lordship.
Sorry?
Still 1 year, Anganwadi worker is not there. I am also in both. I have completed. Page, Lordship.
So already they have selected.
No, my lord.
No.
Not my lord. Already, my lord, director directed the CDPO to make fresh advertisement. Because she was the only person, her appointment was illegal. That's why cannot be approved.
No, it's not illegal.
How it is
Yes.
illegal?
No,
Where is it illegal?
subject to approval, but there is no approval letter.
No, but she was allowed to continue.
It's only CDPO, my lord, not by the director. And hence, director says
No.
you make fresh advertisement.
According
We
to-
have annexed it,
So
lordship.
as and when advertisement comes out, then we'll see. Right now, that prayer cannot be accepted.
Lordship, question is that, Lordship, according to judgment, Lordship, those who have complete 6 months in a permanent post in a temporary basis, he deems to be a permanent post. It is
No,
a
no,
Supreme
what is your prayer here, Mr. Alamgir? What are you seeking?
I also, my
Question is that I have
lord,
12 years experience, Lordship.
All right, on the prayer of London Council. You can't even answer a simple question. I asked you, what is your prayer? You are saying
My
what?
prayer is
How many years of
kindly,
experience you have?
promote me. Only I am only candidate, and it is Kashyap Punji. I am also Kashyap.
It cannot be done unless there is an advertisement.
There is no any person, Lordship.
Huh?
Only I am here.
So no advertisement is required.
Advertisement also, I am, it is promotional post, Lordship. Why can I?
advertisement is required. my lord.
Therefore, you do
Application
your
is invited
research.
from
Also,
the.
it is required only 9 pass. I am also 9 pass.
Heard Mr. Alamgir, Learned
Kindly
Council for the
consider.
Petitioner, also heard Mr. Tracy Chutia, Learned Additional Senior Government Advocate Assam, who is referred to the affidavit filed on behalf of the department to submit that the engagement of the petitioner was not in accordance with law, and therefore her tenure as Anganwadi helper cannot be recognized for the purpose of upgradation, public promotion to the post of Anganwadi worker. Mr. Alamgir, on the other hand, submits that his client has rendered voluntary service for more than 12 years, and therefore she would be entitled to for consideration for promotion, public upgradation to the post of Anganwadi worker. Full stop. In support of his above argument, the Petitioners Council has invited the attention of this court to the order dated 12/7/2010 issued by the Child Development Project Officer, Lala ICDS Project, Hailakandi, to submit that the petitioner was originally appointed under an order issued by the CDP of Lala ICDS Project. Full stop. Although there is no written order of extension of her service, yet she has been allowed to continue to render her voluntary service since the date of her engagement till today. full stop, contending that the petitioner is the only candidate from the PUSCIN community and is a permanent resident of the said locality. Her case deserves to be considered for upgradation stroke appointment as Anganwadi worker. More so, she has been rendering her voluntary service both in the post of Anganwadi helper as well as worker till date. Full stop. The question that would arise for consideration in this case is as to whether, since the engagement of the petitioner as an Anganwadi helper, wide order dated 12/7/2010, has she been continuously rendering her voluntary service as Anganwadi helper under the Lala ICDS project? Full stop. If that be so, then there can be no doubt about the fact that the petitioner would have acquired the qualification of being considered for promotion to the next higher post of Anganwadi worker. Full stop. It is, however, not the case of the petitioner that any advertisement has been issued by the authorities for filling up the post of Anganwadi worker under the Lala ICDS project. Full stop. Situated thus, I dispose of this writ petition by granting liberty to the petitioner to file appropriate application stroke representation along with supporting document so as to establish that the petitioner has been continuously rendering her voluntary service as Anganwadi helper under the Lala ICDS project since 12/7/2010. On receipt of such application, the Director of Social
Women and Child Development.
Director of Women and
Child Development.
Child Development Department, Women and Child Department, Assam, that is the respondent number 2, shall cause an inquiry being made on the claim made by the petitioner and thereafter pass appropriate order is addressing her grievance. If it is found that the petitioner has been continuously rendering her voluntary service as Anganwadi worker under the Lala ICDS project for more than 10 years and meets the eligibility requirement for being appointed as Anganwadi worker, her case shall be considered in accordance with law as and when proper advertisement is issued by the department on that behalf. With the above exercise be carried out and completed within 3 months from the date of receipt of representation to be submitted by the petitioner before the respondent number 2. With the above observation, this petition stands.
Obliged.
May it please my lord. While the other side have filed the affidavit in opposition, I pray to file my affidavit in reply. Take some time.
P.R. Sharma, Lord Counsel for the petitioner, submits that 3 weeks time be granted to submit rejoinder affidavit in response to the counter affidavit filed by the respondents. Mr. M. Sharma and counsel for the respondents is present and does not have any objection if the prayer is allowed. In view of the above, let this matter be listed again after 4 weeks. In the meantime, rejoinder affidavit, if any, be brought on record by furnishing advance copy upon the respondent's consent.
My lord, we have placed our representation for release of provisional pension before the branch manager of the said bank. My lord.
Tendency of the writ petition shall not be a bar for the authorities to consider the prayer for release of provisional pension made by the petitioner before the branch manager.
Lordship, matter may kindly be bus over for a time being, Lordship.
What is this matter?
Lordship, affidavit is ready and it is sent for vetting. Some more time required to file this.
Gradation list, let them file the affidavit. Heard Miss L. Aomi, learned counsel for the petitioner. Ms. S. Borua, learned government advocate Assam, submits that affidavit on behalf of the department is ready and the same has been sent for vetting. Therefore, a prayer has been made to post this matter again after the summer vacation, so as to enable her to bring the affidavit on record. Miss,
Please, your lordship. I appear for response number 4, your lordship. Even today we have filed an affidavit, your lordship.
Miss, your name please?
N. Mahanta.
And Mohanta, learned counsel for the response number 4, submits that affidavit on behalf of her client has been filed only today morning, but the same is not on record. The registry to therefore list the matter again after summer vacation by tagging the affidavit with the record of this
Deeply obliged.
affidavits.
Lordship, kindly pass over the matter of timing.
This matter, we have received instruction, we would like to file affidavit. Regarding my lord, DP, my lord, department proceeding.
Yes, they want to file affidavit.
No, lordship.
No affidavit. What is the no about?
Lordship, pass over the matter for timing.
Okay.
You wait for.
Okay.
On the last occasion, the lordship has issued notice of motion, my lord, on 26/4/2023. The matter pertains to grant of minimum scale of pay.
34, my lord, we find a difficulty. My lord takes up a petition and party structure. Who work where? There's no whisper about it, my lord. All have been jumbled up. Some people from.
File your affidavit.
Yes, my lord. Nobody, and no, my lord, as regards if they are entitled, my lord, we need to have instructions. Where were they working, my lord? Nolbari, Baksa,
Perhaps my
Border,
learned friend will have to go through paragraph 3 of my writ petition.
You file your affidavit.
Perhaps he'll have to go through the.
I know. I'll
proper
come to
manner.
All right, I heard Mr. A.K. Borua, learned counsel for the petitioners. Also heard Mr. D. Gogoi, learned SC, the Forest Department. Forest Department, Assam, who prays for and is granted 6 weeks further time to obtain instruction to file affidavit. Mr. B. Gogoi, learned SC, Finance Department, Assam, who is standing near the door. You are not appearing in this case, Mr. Gogoi, Finance. Department, Assam. Present on behalf of
Finance
had already given the approval.
No, my lord, there's some issue. I'll address in the affidavit. my lord.
State.
Not
Present
simple
on
as it seems.
on number 5. On the request of the learned department counsel appearing for response number 1 to 4, this matter stands adjourned for 6 weeks.
Deeply.
This is after notice for consideration of
They
interim.
want
I
to
know, my
time.
lord.
Is there any interim order here?
No, my lord, while issuing notice, your lordship had observed that interim will be considered on the returnable date. Earlier also they have taken.
That is a polite way of declining an interim order. Is
I'm
that?
not sure, my lord, because there is a delay of almost 6 years. They have also not done anything so far as the department.
What is the interim order you're seeking?
I am not sure whether I am told, my lords, he will be in a better position. Now they are after 6 years seeking to appoint an inquiry officer.
So what is your interim relief?
Interim relief, my lords, they should not proceed with it. If they have not proceeded for 6 odd years, lordship.
This is subjudice matter. You file your affidavit.
I have received instructions when an inquiry officer has been appointed.
Just now, my lords,
After 6 years.
Your lordship I'll tell your lordship, it's an interesting question, my lord. The show cause notice was issued on 7/7/17 and the inquiry officer now has been appointed in 23. Otherwise, the interesting point is this, my lord. Your lordship in Ajit Sanuwal has already cleared the law so far as the review within 90 days applies even to 6(1) and 6(2), and the suspension order does not survive if no charge sheet is passed within 90 days. Now, this person was arrested on 13/6/16. On 14/6/16, the following day, he was placed under suspension. Whether now it makes no difference after Ajit Sanuwal because 6-1 or 6-2, that
You have,
my lords, I have now.
yes,
Then, my lords, he retired on 31/3/17. Subsequent to his retirement,
yes,
the show cause notice is issued. Now, under Rule 21 of the pension rule, so far, if you want to institute a departmental proceeding after retirement or further reemployment, the sanction of the governor is required. But in the explanation, the date of departmental proceeding so far as is either the date on which the charge sheet is issued, which admittedly is post-retirement. But if you are placed under suspension, there is a deeming provision which says it will relate back to the date of suspension. So the issue here is whether I was under suspension or on regular service on the date of retirement. If the principle of Ajit Sonowal is applied, then the suspension order would have lapsed in September 16, and on the date when I retired in much later thereafter on 31/3/17, that suspension order does not survive, so I would have to be treated as a regular employee, and therefore under the pension rules for proceeding, instituting a departmental proceeding after retirement.
so you are saying by fiction.
By fiction
by
is
legal
under the
fiction.
rules, but I am saying because the suspension order lapsed now by operation of law, your lordship will note
That's
the
right, so that's what I'm asking.
My lord.
Your stand is that
My
in view of the legal fiction,
My-
which has
my-
been clarified after the Ajit
Ajit,
Sonowal,
your lordship is right. My lord.
you would have to be
Treated
deemed to have been an employee in
my lord,
service.
that is the short point.
And therefore, after retirement, the law would
Thank-
come in the way of,
Yeah, sanction of the governor would be required. That is the
Uh,
short point.
it is not proper for you to now unleash the inquiry on him after he has filed the writ petition.
Too belated matter, that I'll admit, but since matter, government is taking it a bit seriously, so I'll, without affidavit matter, it wouldn't be proper on my
No,
part.
that is all right, you file your affidavit. But if you ignite the process now, then we'll have to come down.
My-
So better instruct your clients accordingly. We are now examining the matter. Heard Mr. P.J. Goswami and senior counsel, assisted by Mr.
Is it a-
PJ doctor.
P.J. Dutta and counsel appearing for the petitioner. Also heard Mr. D. Gogoi, Learned Standing Counsel, Environment and Forest Department, Assam, who submitted that he has received instructions and shall bring it and shall file affidavit within 3 weeks from today. On the request of Mr. D. Gogoi, Learned Standing Counsel, Forest Department, Assam, this matter is directed to be posted again after 4 weeks. Since this matter is now sub judice before this court, it is expected that. No, we'll not write that. Let me.
No, he'll convey, my lord.
That you communicate,
My lord,
but don't trigger action. Then we'll have to come down.
my,
That's it.
Always deeply obliged.
We can take it back, Mr.
My lord. Yeah.
Yes, yes.
In this case, my lord, the petitioner before your lordship was, my lord, appointed as, my lord, constable, my lord, in CIF, SAF, my lord, case 21, my lord. And while he was in probation, my lord, his, my lord, qualification, my lord, was, my lord, verified, my lord, and due to, my lord, the wrong, my lord, report from the university, page 26, my lord, he was, my lord, terminated, my lord. He was appointed on, my lord, 1/7/2021, my lord, and due to report dated, my lord, 28 June 2021, he was terminated on, my lord, 6/11/2021.
6/11.
6/11/2021. Thereafter, my lord, they communicated, my lord, that my lord, due to lack of, my lord, all the documents, my lord, they submitted this report, my lord. Page 30, my lord, subsequently, my lord, they clarified that, my lord.
Just 1 minute, just 1 minute. Please take your seat. I'll ask you. All right, now, yes, what has happened now? No inquiry was made with the Kumar Bhaskar Verma Sanskrit and Ancient Studies University.
Yes, my lord, then it was not verified.
My lord, I'll
What
just
has
explain,
happened
my lord,
here?
what has happened is, he was serving in the armed forces, my lord, and then the mark sheet was sent to us for verification. At that point of time, my lord, it was a director.
Ask means whom? Ask
My lord,
means-
it was first sent to the director of higher education because the Sanskrit board was functioning against under the director of higher education. Later on, the Sanskrit board was reconstructed as the Kumar Bhaskar University, my lord. So now when the matter was sent from the director of higher education to the Kumar Bhaskar Verma University, on our records in the first, when we first went to the records, he was shown as a failed candidate. That is the report we sent, and it is on the basis of that report.
Where is that report? Page?
My lord, that report would be at. That report, lordship would find at the. Yes, in his affidavit, my lord, that is there.
Page 53, my
Page 53, my lord,
of my APD.
of the affidavit in opposition filed by the
Just number 1 to 6.
respondent number 1 to 6. Annexure H. The second paragraph, last 4 lines.
Yes.
May I read the last 4 lines, my lord? Starts with the word point 4. Third line from the top, if paragraph 2. Point 4, regarding the same, this office has gone through the existing record of the candidate and found from the tabulation sheets from the marks obtained by the candidate with roll number so and so, the candidate has failed in the Provisional examinations 2013. As such, the letter sent by this office declared the mark sheet and certificates are fake because genuine certificate does not declare a fake candidate passing in the second division. Now, my lord, thereafter, after he's lost his job, he again approached the director of higher education, who sent us an information that this person did not pass in the usual course, but had passed on a recalculation of marks. When we traced the recalculation of mark sheet, the recalculation of marks done, we found that actually he had passed in the recalculation. It was a true fact. That we have brought on record by filing an affidavit, my lord. An affidavit by the respondent number 7, which was called for on the last occasion. And there, my lord, at if lordship has page 4, paragraph 6 of the said affidavit.
The deponent also stated again on 6/4/2022, the office of the deponent received another letter from the Deputy Director of Sanskrit Education, Assam, regarding verification of the same candidate along with the report of the Pradhan Adhyapak. This time the letter enclosed with all the documents of the candidate, that is mark sheet, admit, pass certificate, registration, and it was informed to the university that the candidate has passed in re-evaluation. After verification in the re-evaluation tabulation sheet, office of the deponent declared the candidate passed in the re-evaluation and communicated the same to the Deputy Director of Sanskrit Education. But my lord, by this time, the candidate had already lost his job on the basis of the earlier report. Therefore, he is before this honorable court, my lord. Now, if it is when it is a fact that he had passed on the re-evaluation, perhaps termination, my lord.
But what kind of a report this Bhaskar
My
University?
lord, that happened because when
Casually.
my lord, the Sanskrit board, when it was there, it maintained the records in a very poor form, my lord. Even at this stage of time, for those records, we have roll numbers. We do not have the name of the candidates, the father's name. It was maintained in
I
such a
heard
way in the
Mr. M.
Sanskrit board.
Bhavriya, learned counsel for the petitioner. I also heard Mr. A.K. Datta, learned CGC, appearing for the respond numbers 1 to 6. Mr. R. Majumdar, learned counsel, has appeared for the respond number 7. First step. The petitioner herein had passed his Hindi Praveshika examination in the year 2013. And thereafter, he had cleared his higher secondary examination under the Assam Higher Secondary Education Council, Guwahati. Full stop. The Hindi Praveshika examination is treated as equivalent to a high school leaving certificate, bracket HSLC, bracket close, or matriculation examination, full stop. Based on his above qualification, the petitioner had submitted his application for selection and appointment as constable stroke GD in CISF on the basis of the recruitment process conducted by the Staff Selection Commission of India. Selection and Commission. Is it Selection and Commission?
Staff Selection Commission.
Staff Selection Commission of India. First up. Pursuant to the aforesaid process, the petitioner emerged as a successful candidate and he was accordingly issued appointment order dated 01/07/2021, pursuant whereto the petitioner had joined as constable at the RTC, Bhilai, Chhattisgarh on 09/07/2021. While the petitioner was undergoing his 2 years training program, the authorities had made an inquiry so as to verify the educational qualifications of the petitioner, including his qualification of having passed Hindi Praveshika examination. First up. Initially, the inquiry was sent to the Deputy Director, Sanskrit Education, Deputy Director of Sanskrit Education, Assam. But since the matter was dealt with Assam Sanskrit Board, the communication was rerouted on 28/6/2021, addressed by the Group Commandant, Chairman, Dossier Scrutiny Board for recruitment of constable, bracket GD, bracket close. First up. The Assam Sanskrit Board had replied that it was no longer in existence, and accordingly, upon reconstitution, all its records were transferred to the Kumar Bhaskar Verma Sanskrit and Ancient Studies University, Nalbari. First up. Upon receipt of such information, an inquiry was made with the Kumar Bhaskar Verma Sanskrit and Ancient Studies Universities, Nalbari, represented by the respondent number 7 hearing. Full stop. Upon such inquiry, a communication dated 29/9/2021 was sent by the respondent number 7 to the chairman of the CISF Group Headquarters Guwahati, informing him that the petitioner had failed in the Praveshika examination, 2013, and therefore the mark sheets and certificates submitted by him were fake, since a genuine certificate would not declare a failed candidate as passed in second division. Taking note of the communication dated 29/9/2021 issued by the respondent number 7, the authorities had issued the impugned order of termination dated 6/11/2021 by invoking powers under rules 25 and 26 of the CISF rules, 2001, thereby terminating the services of the petitioner by giving him 1 month's salary in lieu of 1 month's notice. Consequently, the petitioner had lost his job due to the communication dated 29/9/2021 issued by the respondent number 7. Undeterred by the aforesaid developments, the petitioner had apparently once again approached the respondent number 7. Is it?
Through the Sanskrit board,
Through this.
through the deputy director Sanskrit. Assam.
Through the Deputy Director, Assam Sanskrit Board, assailing the aforesaid report. It was on this occasion that the matter was re-verified, whereafter it was found that the petitioner had actually passed the Hindi Praveshika examination in second division as claimed by him, and therefore the projection made in the communication dated 29/9/2021 was incorrect. Having detected the aforesaid anomaly, the respondent number 7 had filed affidavit in opposition dated 23/6/2023, disclosing the above facts. The amendments made in para 6 of the affidavit would be relevant for the purpose of this case, and therefore is being reproduced herein below for ready reference. It is in affidavit filed by respondent number 7, page 61, running page 61, para 6. From the above stand by the respondent number 7, it is crystal clear that the petitioner had in fact passed his Hindi Praveshika examination in second division in the year 2013. However, for no fault of his own, merely due to a miscommunication or erroneous communication issued earlier by the respondent number 7, he had to lose his job for no fault on his part. From the above, it appears that the respondent number 7 had adopted a completely casual and cavalier approach in such an important matter, thereby causing serious prejudice to the petitioner. However, so as to defend his client's interests, Mr. Majumdar submits that after the reconstitution of the Assam Sanskrit Board and creation of the Kumar Bhaskar, whatever it is, Kumar Bhaskar Burma,
Sanskrit and ancient study.
Sanskrit and Ancient Studies University.
Sanskrit and Ancient Studies Universities at Nalbari, there were a lot of anomalies in maintenance of records as well as transmission of records, which had resulted into the aforesaid error. However, on re-evaluation of this course, as soon as the respondent number 7 had detected the mistake, it was communicated to the concerned authorities. Be that as it may, the fact of the matter is that there was no justifiable ground for the respondents to issue the order of termination dated 6/11/2021. Mr. Datta, Lanes CGC has also fairly submitted that after the affidavit filed by the respondent number 7, the matter is now clear, and it is evident that the petitioner's services were terminated on an erroneous communication received by the respondent number 7. If that be so, this is a fit case where the order of this court is of the opinion that this is a fit case when the order of termination of service dated 6/11/2021 deserves to be set aside with the direction to immediately reinstate the petitioner back in service. Ordered accordingly, the order of termination dated so and so stands set aside. The respondent numbers so and so 1 to 6 are directed to take necessary steps for reinstatement of the petitioner back in service with full
Consequential benefits.
with full consequential benefits as may be permissible under the law, including his seniority and notional, including his notional seniority
Continuity.
and continuity in service. Full stop. The order of this court be complied within 3 weeks from the date of receipt of a certified copy of this order. Petition stands allowed to the above extent. Parties to bear their own cost.
My lord, I have submission, whether consequential benefit.
Hmm.
Because we have no call. My
So
lord,
seniority you have to give him.
seniority, my lord, consequential benefit in lieu of his termination.
Consequential benefit insofar as notional seniority is concerned.
My lord, there is a judgment, my lord, I have brought, my lord. When illegally terminated, my lord, salary is also given, my lord.
This is perhaps a case which was all on misconception. There was no illegality as such.
So you have to sue
No
as
illegality.
respond number 7. They can't be blamed. They are not at fault. They got the information, so they terminated. The petitioner would be at liberty to avail any other legal remedy as may be permissible under the law, if so advised. With the above observation, the petition stands allowed parties to bear their own cost. Yes. First, get back your job. Don't
My
be
lord,
too
yes,
ambitious.
yes, of course. Diploma.
May I please, Your Lordship?
For my senior counsel staff, may I make one thing, madam? On last occasion, I was directed to take instruction regarding latest position and status party to the process of vacation of regular director IIT Guwahati, madam. Further, I am directed to produce all further instruction pertaining to the process and instructions conducted for appointment, appointing the respondent number 5, agent officiating director, madam. But I have not received any instruction from the Ministry of Education, madam. Although I have communicated, madam. Last order, madam, 22, madam. 1000.
You can go to IIT now. Monchamo petition. Monchamo petition. 3 Monchamo 3.
Yes, what is the matter, Mr. Goswami?
Yes, may I please, Your Lordship? I beg to point out, Lordship, that initially I was appointed and engaged by respondent number 5 in this matter.
Hmm.
But subsequently, IIT has been made a party. I being a standing counsel. I have withdrawn my Lordship that Wakalatnama. And the file has been returned to respondent number 5 by my learned junior Lordship. So I'm not representing the aspirant number 5. That's what I'm like to point out to your lordship.
You are representing whom?
Only for IIT Guwahati, aspirant number 7, lordship.
What is the matter about?
Yes, may I just. I had occasion to place this matter before lordship also on 3rd of May. But that was just for orders. And the notice was issued on 5/4/23. And that order, the first order itself, my lord, directed the central government to keep the records available for the court. If you lordship see that, and till now, that has not happened, and I don't want their records because I have got their affidavit and I'll proceed with my case on the basis of that. If your lordship sees this order, last paragraph, however, in the meantime, the respondents IIT and Department of Higher Education, Ministry of Education, Government of India are to keep the relevant records available pertaining to selection and appointment of the director in charge, as well as the selection process for the regular director for perusal by the court if so required. This was done, my lord, on 5/4/23, when notice was first issued. Till now, we have not been able to have that record, but now we have the government's affidavit, therefore I am.
So what is the
short
core
point.
issue?
Two short issues are involved. This relates to the IIT Guwahati. The director, who was a regular director, he was appointed as a director in another Government of India organization, that AICT, All India Council of Scientific Research and Technical Education. So there was a vacancy. Therefore, an officiating director had to be appointed before the regular selection of a director. Under the IIT Act, as well as the statutes governing the IIT Guwahati, there is no provision, my lord, as to how that officiating director is to be appointed. There is no specific provision for that. The only thing which is available is the first meeting of this council under the Act, which your lordships will see at page 25. It starts at page 24, my lord. It is the actually it is at page 22, my lord, the first page. Minutes of the first meeting of the council. Council is the, my lord, central body presided by the Central Minister for Education. For 4 Indian Institutes of Technology established under the Institution of Technology Act, so and so. The first meeting of the Indian Institutes of Technology Council was held in New Delhi on 25th of May, 1962. It was presided over a very interesting document. Professor Himayan Kabir, Dr. B.C. Roy, S.K. Bose, then Chandirani and R.D. Soksi. Now, there is a provision only in this meeting, which was done, which your lordships will kindly turn to page 25, item number 7. First part is the regular appointment. The second part, in the case of short-term vacancies or appointment on an officiating basis, pending selection as per above procedure, the chairman of the council should make the appointment in consultation with the chairman of the concerned board of governors. So this is the provision by which, my lord, the officiating director will be appointed. The appointing authority is specified. He is the chairman of the council, namely, that central body. And the minister education is
So
the.
I'm just interrupting you for a minute.
Yes, yes.
What is the order are you seeking any order today from the court? Adjudicatory order?
Yes, my lord.
What is that order?
My lord, I don't know, my lord. There are two orders I seek from your lordship. Your lordship's order, my learned friend has brought it out. The prayer for interim order will be considered on the next date fixed. The learned Central Government Council to produce the relevant record. That is your lordship's order, I think. No? Yes, this is the order of 3523.
What is the interim order?
Yeah.
What is it?
Well, there are two things. The government has now, central government has filed the affidavit. In our petition, we said that our inquiry is revealed and which is now established by the documents which has come with the government's affidavit, that it was the governor of the IIT board who really made the appointment. I'll take your lordship straight to the document. Kindly have a look at the affidavit of the 1, 2, 6, below. 1, 2, and 6. This is the respondent's affidavit. First to page 60, page 61. Kindly turn to page 61. This is the first mail dated 2011-22.
So what is the order you are seeking?
Milord, I am seeking twofold order. One is that this officiating appointment is expressly illegal. Therefore, it needs to be stayed. And I draw your lordship's kind attention to the order itself, which can take in such an interim order. If your lordship just have a look at the order appointing him, that will be better. Why I am saying that it will be clear. Page 30. This is the order. There are 3 of that order. It has also been decided with the approval of the Honorable Minister of Education in his capacity as chairperson, IIT Council, that Professor T.Z. Sitharaman, he was the existing director who has gone, may hand over the charge of the post of Director IIT Guwahati to Professor P.K. Iyer, Department of Chemistry, IIT Guwahati, who will act as officiating director IIT Guwahati till regular incumbent takes over or till further orders, whichever is earlier. You may like to take further necessary action in this regard. So the order was officiating order. 2 situations, till regular incumbent is appointed or till further orders. Therefore, there is an option where this officiating appointment, if your lordships find that prima facie it is absolutely without jurisdiction, your lordships can give a direction for the proper order to be passed. That is one. Secondly, as I show you from the facts, the chairman of the Board of Governors, he has not only passed an order appointing the respondent 5 as an officiating director, who is at the 59th position of the seniority list, superseding 58 senior officers, And he is now going to, and then when a query was made, he said that he has reviewed and none of the other senior officers fit enough to be an officiating director. So he has virtually expressed his views, which has disabled him from participating in the process for regular selection of the director. Because he has, and must be not 58, he says he has reviewed and they're all listless. They are not fit enough.
Is it in writing?
Yes, yes. it is
Which
in
page,
writing.
which page?
Yes, that is what I wanted to show. So basically two allegations. One, that this appointment itself is by a person who had no authority. And secondly, he cannot possibly sit in the selection process after what he has said about the other professors. Kindly now turn to the government's affidavit. We allege that now it is being confirmed. These are the three relevant mails below. It's a case of 4 mails now. I thought it was a case of 3 mails. It will be 4 mails. I'll just show it. Page 61 first. This is sent by R. Modi, who is the chairman of the Board of Governors of IIT Guwahati, to the Secretary Higher Education in the Ministry, Government of India. In pursuance of the letter dated so-and-so, 17 November, of the Department of Higher Education, Ministry of Education, Government of India, Professor T.V. Sitharaman, who is the existing director at that point of time, Director IIT Guwahati, who is appointed as Chairman AICTE, may be relieved from his duties from IIT Guwahati in early December 2022. That relates to the existing director. Now, this is the second paragraph, which is troubling. As per the statutes of IIT Guwahati, I, as chairman of the Board of Governors, appoint Professor P.K. Iyer as director in charge of IIT Guwahati until further orders, and entrust the charge of the director in charge of IIT Guwahati to Professor P.K. Iyer with effect from 9th December 22. Professor T.G. Sitharaman, director, may be relieved on 9th December so as to allow him to report to AICT as chairman at earliest. Therefore, this Milord order or bill, he exercises a power which he thinks he is empowered under the statutes and appoints the officiating director. This ex officio is without jurisdiction. It's a nullity.
So what is the position of appointment of regular director?
Yes, that has been issued, Milord. The advertisement has been issued, which your lordships will see in the writ petition. Last annexure at page 33. Last annexure, page 33. This is last date has been fixed on 28/2/23 for receipt of applications. And if your lordships see this, this is also interesting. Applications are invited for appointment to the post of Director of Indian Institute of Technology, IIT Guwahati. Director of an IIT is the academic and administrative head of the institution. He is expected to have a minimum of 5 years administrative experience and leadership qualities to head an institute of national importance. The candidate person should be a PhD with first class or equivalent at the preceding degree, preferably in branch of engineering. In exceptional cases, candidates with science, mathematics, or management degrees may be considered. She should have an outstanding academic record throughout and minimum of 10 years teaching experience as professor in a reputed engineering.
So
or
what happened after this? What is the stage of the recruitment? New process.
After this, we were told earlier, and the affidavit also says that the 300 applications have been submitted. It's virtually a global response. Director of an IIT, a lot of people apply. So apparently, 300 applications have been submitted. And the shortlisting is, according to them, on the last occasions, they said that shortlisting is going on. But it is almost, your lordship can see the period from April onwards. So the last date was February 23. So shortlisting possibly is underway, or maybe.
Well, what is the stage, Mr. Patel?
That's what
That central government can tell, Lords, because we are not.
that they will never receive. So let us forget that.
No instruction we have called for, you have to give it. And who is the officer? We'll call him here. Let him come. Yes, you say. Let the secretary come then. Under secretary? We'll record that you have no objection if he's summoned personally. Huh? No, you are not doing your job, Mr. Bhattacharya. The court is asking for instructions, you are not getting it. Then we will have to call for the officer personally.
Even that 10 years which is required, the gentleman who was appointed as officiating, on the date of appointment, he didn't even fulfill that 10 years as professor. 59th position in the seniority list, and this gentleman, as governor thinks, is authorized under the statute to appoint a officiating director and passes an order appointing him. That's a nullity first. And now kindly have a look at the other.
Now, Mr. Goswami, I'm having to ask you this.
Yes.
This matter will have to be then heard finally. We can't, by an interim order, we can't interdict with the officiating appointment. That is the view.
No, your lordship, that is up to your lordship. We'll make that prayer. Your lordship will consider whatever your lordship feels. That will be ultimately the.
But yes,
but
expediting the regular process, and if a view is expressed by someone.
No, that is one. The second aspect is important. And I want to show your lordship why I am making that submission. Kindly see, this is the first your lordship has seen at page 61. He makes the appointment and sends it to the director. Now see the second reply of this to the chairman by the secretary, which your lordships will see at page 72. The last part. This is from Rakesh Ranjan, who is the secretary, to whom that 61 mail was sent. And this is on the next day, 21st of November, 9:31 morning. And just see his mail. Next page. Dear Dr. Modi, thank you so much for taking time off your busy schedule and sending the recommendation for the charge arrangement for the position of Director IIT Guwahati in this connection. Following further details may kindly be sent. Is Professor IR senior most? If not, any reason for not recommending the names of any of those who are senior to him? Seniority list of faculty members in IIT Guwahati and details of faculty members holding senior administrative positions, deans and deputy director. The petitioner is the deputy director. The details may kindly be sent at the earliest so that the recommendation could be submitted to the Honorable Minister in his capacity as chairman of IIT Council for a decision. And this reply, your lordships kindly turn over to page 72. Just
Yes.
The next. The middle one, Miller, from Rajiv Modi and all that. This is on the same day, November 21st. Time is in the afternoon. The earlier one was in the morning, 3:11. Now this is his reply. Hello again. He is younger, energetic, and has many accomplishments to his credit, as sent as attachment in my earlier email message to you all. The other seniors had been reviewed by me, 58 of them. The other seniors had been reviewed by me, and in my judgment, they would not be able to carry on with the momentum of upgradation that we have had at IIT Guwahati in the past years. Professor Iyer has been involved in many ways in the development of IIT Guwahati during the time of previous director, as well as during the tenure of Professor Sitaraman. So he will enable smooth transition. Thank you for your understanding. So this is his reply. He says he has reviewed all seniors and they are not fit enough to be deputy director, officiating director. Now the director has sent 71, kindly have a look. It starts from 64. Page 64. This is from the director, outgoing director, Sitaraman, and it was sent on November 21st, 22, and to the Secretary, Union of India. Dear Sri Rakesh Ranjan, please find attached posted list of professors of IIT Guwahati. So the entire list is given. Your lordships will find at page 65, serial number 22.
So petitioner is not the senior most.
He is not the senior most. He is serial number 22 at page 65. And he is the serving deputy director, regularly appointed. And then, my lord, your lordship will find next page, 66, serial number 59, Professor Parameshwar K. Iyer. That is the person who has been chosen by the governor and appointed as an officiating thing. So this is.
So what I propose to do is we'll fix this matter immediately on reopening, giving him one last chance.
May I just say one page? Kindly bear with me. Kindly turn to page 71 because this is a continuation. He has given the entire list of 197 professors.
Reassemble again. There is some meeting.
As your lordship.
But we'll post it after the immediately on reopening. You have to give us the information in the form of an affidavit.
Let your lordships come back. I'll show this and make a little submission so that your lordships has a perspective of the entire position. After that, your lordships can decide.
Anybody has appeared for respondent number 5? After you
So for my information, no one is appearing. Respondent number 5 has filed the affidavit. There is nothing. So far, he is
little late in sitting. We are having 2 meetings in between. So that's what judges will have to go through every day. From 1 to 2:10 meetings. And then again, hearings. Anyway, please continue.
Oh, occupational hazard.
Yes.
May I please, your lordship, I was at page 71, after the list. If I may just. That respondents 1, 2, and 6 affidavit. I have placed the emails and the list of thing is up to page 71. This is sent by the director to the Education Secretary, Government of India. which your lordship has, it starts at page 64 and this list continues up to 71 and then this at page 71.
Yes.
In the list, Professor PK IR is at serial 59. May kindly be seen serial so-and-so, so-and-so, so-and-so as vigilant case. Some of the senior professors may be not interested or not good for R&D. Deans, senior and DD, two resumes have been attached. This is the part I am saying that director has sent out of this two resumes. One, the first person, Professor Punyamurthy, serial 26, his views on him. And number two is the present petitioner, Deputy Director, and his views on him. So these two were the recommendations emerging from the then director, and this was sent. We don't have anything on record to know as to what has happened to these resumes, whether somebody applied his mind, considered or not considered, we don't know. But this has come in the union's affidavit that these two resumes were sent by the outgoing director. And my lord, so far as this practice is concerned, in the history of IITs, this has happened for the first time. The history and the options exercised in respect of officiating appointments, we have pointed out at page 6, my lord. If your lordships, yes, 3 options have been exercised in the past. Paragraph 4 at page 6. One is to ask the deputy director if in position to take over the charge. 2, the senior most professor of the institute or the next senior most professor if the senior most is not willing or is not found suitable. Or 3, director of any other IIT so to soldier the added responsibility. These are the 3 options exercised wherever it was needed, right from 61 till now. This is the option exercised. Therefore, my lord, it is a very unprecedented case that you take out the 59th person who doesn't even fulfill the requirement of your advertisement for a regular person at that point of time. In January he completed, but December he was not even completing 10 years. And the affidavit of IIT is before your lordship, which at page 50, which it says that he was Dean of Public Relations. He is basically a person from the chemistry department, but Dean on Public Relations. That is the affidavit at page 50 of the IIT Guwahati for ranking and all that. And your lordship has seen the advertisement that it is only in exceptional cases that you go to the science stream. Otherwise, basically, it is a technological, I mean, it has made a huge name all over the world. That's why your lordships are finding 300 applications for a director's post and coming all over the world, different parts of the world. Therefore, my lord, it is not merely an individual case, my lord, that somebody has been overlooked. If you are introducing something of this type, you are creating a precedent which will undermine the integrity of these institutions which have grown if it is going to be repeated. That is why, my lord, it is necessary to be pointing out that this is something unusual and this should not be resorted to. Therefore, we, apart from anything, we prayed for a declaration to that effect that it is not in the public's interest to supersede in this manner and do things the way it has been done, because it was never done. And that resolution.
So, Mr. Goswami, if I've understood your case correctly, you want that his respondent number 5's officiating appointment should be set aside.
Yes.
And who should be appointed as officiator?
They should follow the procedure and do it.
Procedure means the senior most.
Whatever the 3 options they have exercised in the past.
But nobody else senior to the petitioner has come before the court.
No,
There are
but
others senior to him.
because it is the responsibility of the authority who is going to exercise these powers. There is a tender.
That is correct, but the petitioner cannot be appointed.
Petitioner is a director, that is an option. Earlier exercise. He is a deputy director, regularly appointed. His term will be expiring in the 16th of December. But he could have been. And his name
No,
was
I'm asking
forwarded.
in this
The
petition-
outgoing director forwarded his name. These are the 2 names here.
What I'm asking is, in this petition, no writ is sought directing the respondents to appoint him.
No, I don't want that. It's not that personal request. I am fighting on a matter of principle that if you allow this kind of deviations from your established precedents, then you are exposing yourself for the future to a situation where the image of these institutions may be undermined. That is something of public interest, and that is the importance of this matter. Otherwise, it has no importance whether X or Y becomes officiating thing. But you are superseding 58 professors with a view that they are no good, unfit, and you have not had the time to review. Humanly, it is impossible that you review 58 cases in one day and then pick out 59. He's a successful, the respondent is a successful public relations officer. I can understand that.
That proves his mettle in a way.
Beg your pardon?
That proves his mettle in a way.
Yes, but not for the heading the IIT. That is for something else. I was thinking, Milord, your lordship asked me, what do you want? I remembered Charles Dickens' Oliver Twist. There is a reply to the hero of that book, Oliver Twist. When he was asked, we want more. That is what his answer was, because he was given something and the person giving was asking, what do you want more? He said, we always want more. Lawyers are something of that kind.
No.
You can't help it.
This is the only channel where the eyes and ears of the courts are opened. This communication is the only method.
That is so. My respectful submission is this: there are twofold prayers. One is that, as I placed page 30, there is an option. It is not till the regular person is appointed. They can still have a different, follow the rule and have somebody. And that the court can pass an interim order that this procedure which was followed was not called for. Therefore, you follow your traditional procedure and appoint whoever you like during the pendency of that regular selection. That is number one. Two, if your lordship is not inclined in any way, at least for the regular selection, the person concerned, namely the governor of the board of directors of IIT Guwahati, he should not take part in this proceeding because he has already expressed his mind with regard to the 58 professors in the most casual way one can think of. After all, these are our prized institutions, Milord. People talk about all the oldest 4 institutions globally. Our people are many different.
So who is appearing for respondent number 4? What do you have to say? Is that all? Anything else?
Yes, my lord, that interim I was, if your lordship was asking, these are the two interim I can think of, my lord. And this is important because if this is, my lord, it is as bad as a supersession of 1973 of Supreme Court judges. You introduce a different method which ultimately undermines the institution. That is not something which should be done. And we have no other forum except the lordships in the high courts to say this, that this is not done. You can't treat 58 professors of an IIT in the method you have done in your union. That message should be loud and clear. It is not for any individual, but you follow whatever you have been following for the last 50 years in IITs for officiating appointments. And at least if that gentleman takes part, there will be absolute apprehension of a possible bias so far as below the selection process is concerned. Ultimately, it is basically that universal proposition that it must not only be fair, but it must be seem to be fair. It is no reflection on him, but his comments and the way he has selected and dealt with the case of the 58 senior professors deserve that that should not be reflected in the regular selection of professors. It will be a sad day if he participates.
All right, yes, let's wind up now. Yes. Why should we allow your client to participate in the selection board? We will restrain. Come here, please. Come this side. He seems to have expressed opinion about the other professors, saying that they are not good enough.
It is to be noted that the views that he had expressed in terms of the professors who are in the university, your lordship, in the IIT. But when the selection process is a global process, lordship, anyone globally can appear for the position. And by the averments made by the petition.
No, that's what he has a bias towards the professors.
Lordship, we'll have over 300 applicants, your lordship. In the following process, to allege bias that out of 299, there are 299 other candidates and only one particular candidate was selected. That is way too far-fetched, lordship, an argument way too far-fetched, lordship, that because it's not an in-house selection process. We'll have applicants all over the world. So it's a very far-fetched argument to say that 299 people will be excluded, only one will be favored. And particularly, secondly, lordship is not like he has the casting vote, that he is the final selecting authority. There's a committee which will select the particular director, lordship. And secondly, lordship, they have pointed out a selection where it stated that the governor of the board of directors of a concerned IIT in consultation with the Minister of Higher Education, who is the chairperson of the IIT Council of IITs, shall make an officiating director for short-term vacancy, your lordship. And the argument that they have advanced regarding those particular at page number at paragraph 4, that this is the procedure being followed, they have not backed it up with any documents, lordship, that this is the past practice followed by the ministry regarding in the past, the following options have been used by the Minister, Education, Government of India, Chairperson, IIT Council to ask the Deputy Director, if in position to take over the charge, the senior most professor or director of any other IIT to shoulder the additional responsibility. That is not backed up by any document. This is the practice being followed. What they followed is a particular paragraph at item agenda number 7, item number 7, where it is stated that the ministry or the chairperson of the council, which is the Minister of Education, in consultation with the Board of Governors or IIT Council, shall take a call over the officiating director. But I want to say, lordship, that meanwhile, lordship, on the last occasion, when the matter came up on 22/6, lordship, instructions were asked that how far has the selection process progressed. So in that case, the learned CGSC was asked to bring instructions to that effect, but which, from what it transpires today, the instructions have not yet arrived. So lordship, if I pray the matter may be fixed on the day of reopening, lordship, meanwhile the instruction may be placed to see how far the selection process has progressed. And we establish that it's a very nascent stage, and lordship may volleyball under the power majesty of this court may well interfere, lordship, but if it has advanced to a very to an advanced stage, lordship, then there may be some issues popping up to stall the process, lordship. So if I may, lordship may kindly not pass any interim order at this stage, your lordship, while we await the instructions of the Ministry of Education regarding what is the stage of the selection process, lordship.
Yes. Yeah, would you like to say anything?
I want it for no role to play.
No role to play.
No role. Done by the ministry and that level.
You also don't have anything to say.
There's only one thing I want to point out. Our reply to respondent 126 at page 3, para 4, we have referred to the reply of RTI, which has come to our knowledge, where also these three formats are options are mentioned. Kindly have a look at page 3 of our reply to respondents 1, 2, and 6. Affidavit in reply to petitioners, to respondents 1, 2, 6. Page 3, para 4. They had brought the records, which was ordered in April. Your lordship could have seen, but this is what we have said. In this context, the deponent has come to learn about the reply of height dated so-and-so 27/2/23 from the Undersecretary of the Government of India to CPIO to queries made in an application under RTI Act 2005, wherein it was stated that in the past, while making acting officiating directorship, the following three options were used by the IIT Council. Was the deputy director, if in position, to take over the charge, the senior most professor of the institute, or the next senior professor if the senior most.
Yes, I've seen it.
That's it. So it is not correct that there is nothing for our statement.
But I heard Mr. P.K. also senior counsel.
Lordship, if I may, lordship. Lordship, may I also point out the delay aspect of the petitioner, your lordship. Lordship, the last date of application was 28th of February 2023, lordship, while we received the copy of the petition on 31/3, your lordship. There was considerable delay on part of the petition approaching the court, lordship. That may also be taken into consideration, lordship.
For the petitioner, also heard Mr. P.S. Bhattacharjee, learned CBC, appearing for the respondent number 1, 2, and 6. Mr. A. Gautam, learned counsel, is appeared for respondent numbers 3 and 4. Mr. R.P. Kakoti, learned senior counsel, assisted by Mr. S. Sutradhar, is present on behalf of the respondent number 7. None is appeared for the respondent number 5. Mr.
Respondent number 5 has filed its affidavit.
Although he was earlier represented by a county council and had also filed his counter affidavit in the matter. The issue raised in this petition pertains to the process of appointing an officiating director of the IIT Guwahati and the steps taken so far for filling up the post of director of the IIT G by means of a regular recruitment process. By referring to the materials available on record, Mr. Goswami has argued that earlier there were 3 options which used to be resorted to by the authorities for making acting oblique officiating for making appointment of acting oblique officiating director of the IIT G, which are as follows. You quoted from para 1, page 1110, double tick to double tick. However, in a marked MARC departure from the established procedure, the respondent number 4 has in this occasion selected the respondent number 5 by ignoring the candidature of selected the respondent number 5 for appointment as the officiating director of IIT by ignoring the candidature of as many as 58 professors senior to him who were equally competent, if not more, to hold the officiating stroke acting in charge of the director of the IIT. Full stop. It is also the submission of Mr. Goswami that the respondent number 4, having expressed adverse opinion about the merit and competence of the 58 senior professors in the IIT, many of whom are applicants for the regular post of director in IIT, he cannot be allowed to participate in the selection board. Full stop. On these two in prayers, the instant writ petition has been filed. Full stop. This court has noticed that by order dated 5/4/2023 passed by this court, passed in this proceeding, the respondent's counsel was asked to keep the relevant records available so as to the relevant records pertaining to selection and appointment of director in charge of the IIT available. Thereafter, on 22/6/2023, another order had been passed by this court asking the learned CBC to obtain further instructions as to the process and the nature of exercise conducted for appointing the respondent number 5 as the officiating director of IIT. Today, when the matter is called up, Mr. P.S. Bhattacharya, learned CBC, submits that although instructions have been called for, he is yet to receive any response from the Ministry of Technical Education, Government of India. Ministry of Education from a Government of India, which is the nodal agency in these matters. From the submission of Mr. Bhattacharya, it is apparent that despite the order of this court, no steps have been taken to furnish the necessary information, stroke instruction, so as to enable the court to pass appropriate order. This, in the opinion of this court, is completely unacceptable conduct of the departmental authorities, more particularly when the petitioner is repeatedly pressing for an interim order from this court so as to preserve the sanctity of the institution, namely IIT. Be that as it may, on the request of Mr. Bhattacharya, one final opportunity is given to him to obtain instruction to produce the records as called for by this court. This matter is accordingly called for by this court on the next date fixed. In this case, the writ petition is accordingly directed to be listed again on 24th of July 2023 as a fixed item. The prayer for interim relief will also be considered on the returnable date. A copy of this order will be furnished to Mr. Bhattacharya, the learned CGC, so as to enable him to do the needful.
Only thing, petitioner's term, there is a fixed term that will expire on 16th of July. As deputy director, he is a professor, he will revert back as a professor. That is the position. And my lord, if they proceed with that, because it's a long gap now, if they proceed with that selection process, then obviously, my lord, this gentleman takes part. He has already expressed his views.
So that I have noticed in the order.
True, therefore, some protection has to be given for that.
No, today they have not notified the, they have not notified the board.
No, he is a part, it's a part of the statute. He is a member of the
There I have a submission, my lord.
Just let me complete. For regular selection, the committee is prescribed under the statute. He is a part of that.
But the board has not yet started interviewing the candidates.
Yes, yes.
Possibly not, I don't know, but last time they said that they are sorting. So if that happens, it will be very prejudicial. That protection your lordship will give.
What is the protection? No interview.
No, interview can take place, but he should not take part till.
That
if-
order will be difficult to take.
If interview, then your lordship will say till 16th, they will not have the interview. Your lordship will consider that on 16th. Or whatever date your lordship has fixed. At least some protection your lordship will have to give, otherwise will not
We'll
be.
have it on 18th instead of 24th, 18th. 18th we'll see.
Because
We'll see, but we'll set aside the entire.
In
selection.
the event, lordship, my lord,
If it takes part,
my
we'll
lord,
set
there are
aside.
more than 300 applications are there. It is, my lord, people from abroad are also.
Mr. Chaudhary, even if one person.
No, my lord,
has an
supposing, my lord, the acting director is selected, then his apprehension will stand correct. If somebody else is selected, my lord, what is his case?
No,
Because.
he's saying this respondent number 4 has already expressed his opinion.
No,
Others are not good enough.
expressed his opinion qua the in charge. How can he express an opinion qua the entire selection, my lord?
No, if those persons are.
There are other persons, he's only one of, out of the 5, he's one of the member.
On 18, if he participates and there is no answer, we'll set aside the entire.
Certainly, my lord.
Your lordship can say that it will be subject to the outcome if they hold the.
If any interview is conducted in the meantime by a board constituted with the respondent number 4 as one of the members, the outcome of the process will be subject to further order that will be passed in the jurisdiction.
Then where is this being?
Yes.
May I pray your lordship? Lordship, I is for implement, lordship. Earlier set of officers already retired. My lord.
What is the IA number?
Lordship,
What is the number of the IA?
I number 1794, like 2023. Lordship.
You want to implement whom?
Lordship, kindly come to page number 3. These officers whom we have already served, kindly come to page 22, annex 2.
You want to implement whom?
The newly implemented at page 3, 1 to 5, this new 5.
And who are the earlier officers? Who are the
Earlier
earlier?
petitioners were all retired. At page 2.
All right, 1, 2, 3, 4, 5. Now, where is the proof that you have demanded compliance?
Yes, lordship, kindly come to page 22, annex 2.
Page 22.
All 5 have received and acknowledged on the same date, 24/5/2023. And your lordships passed an order earlier on
Yes, Lordship, if I may. Lordship,
page 20.
Lordship may peruse order dated 26/5/2023, my lords. Yes, Lordship, now I'm appearing for contempt number 2 in this contempt petition, my lords. Lordship, pursuant to this order, the contempt number 2 has written to the deputy under/undersecretary to the government of Assam, revenue and disaster management, because they are the executing authorities, my lords. Lordship, I can produce the communication if.
Earlier communication.
No, Lordship, this is 16 June, Lordship. This is 16 June 2023, my lords.
So show it to him. We'll implement now, then we'll see.
Yes, Lord.
We've heard Mr. R. Islam, learned counsel for the applicant, also heard Mr. H. Ali, learned counsel appearing for the.
Contempt number 2.
Respondent OP number 2. Full stop. By filing the IA, a prayer has been made by the applicant to implement the opposite parties numbers 1 to 5 as respondents in the
6 to
connected-
10, it will be
as
6.
respondent number 6 to 10 in the connected contempt case. Full stop. I have perused the statements made in the IA. Full stop. According to the petitioner, these opposite parties are responsible for implementation of the court's order, and therefore they are required to be made party in the connected contempt case, since the earlier respondents have already retired from service. Mr. Cholia does not have any objection if the prayer is allowed. In view of the above, the prayer made in the IA stands allowed. The OP numbers 1 to 5 is hereby included as respondent numbers 6 to 10 in the connected contempt case. Registered to make. You have to file amended cost title now.
Not yet.
The petitioner to file amended cost title with the registry within 2 days from today. IA stands disposed of.
Notice will be issued later on, Lordship.
Yes, yes.
Then after vacation, this 2014, Lordship.
You file a cost title, there is a new notification.
Lord.
You've seen this?
Lordship, I have not seen.
See.
Yes, I will file. Diploma.
Notice is online.
Online. But he could be offline, so.
I should be obliged.
May it please your lordship, my lord, I have to take fresh steps, my lord. The notices.
Next steps on
The sole, my lord, contempt.
the prayer of Mr. V.K. Borua, learned counsel for the petitioner. His further time is granted for taking fresh steps for service of notice upon the OP stroke contemptor in this case. Let the matter be listed accordingly.
Highly honored.
Item 37.
My lord, contempt petition, my lord. The amount yet not paid, my lord.
Who is for the opposite party?
Housing corporation, my lord. Earlier it was Ali was appeared. My lord, ordered amount was 12,86,886. Out of that amount, my lord, 10,84,520 was paid. Plus 6. And remaining 2,38,366.
So where is Mr. Arul Chutia? Can you contact him? Otherwise, we have to direct personal appearance, which order will not pass today. If you can get him, fine. Otherwise, we'll give him one chance. All right, I heard Mr. D.K. the learned counsel for the petitioner. None has appeared for the respondent, although the name of the learned counsel for the respondent is shown in the cause list. Must be that as it may, for ends of justice, one more opportunity is granted to the respondent to appear in the matter. List this case immediately on reopening of the summons.
Item 38.
My lord, in this case, my lord, primarily my allegation was against the private respondent of 3, 4, and 5. My lord. Here, the one selection process was done by the department, wherein my lord, without publishing the merit position of the candidate, my lord, the final selection list was issued. Wherein my lord, the private respondent 3, 4, and 5 my lord, were shown to have been selected. My lord.
Why it has been listed today?
But for order perhaps, my lord, I think earlier steps were taken for issuance of notice to the respondent 3, 4, and 5 through the department. Because they
Then why you are arguing on merit?
Lordship, basically, respondent number 4 and 5 service complete presumption.
So and so for the petitioner, so and so for the state, 1 to 4. For respondent number 1 to 4, Mr. Who's appearing for 1 to 4? Mr. J. Henry for respondent number 1 and Mr. 2. B. Chaudhary for respondent number 2, 3, and 4. Is it? You also don't know.
No, 3, 4, 5 are private respondent.
Achha. For respondent number 2, it appears that Respondent numbers 3 and 4 have already been served. Insofar as respondent number 5 is concerned, there is the Lojima Court order dated 31/5/2023, which goes to show that service of notice on the said respondent is also complete. As such, this matter is ready as regards service and therefore be listed for admission after vacation.
All right.
Thank you, Lordship. Lordship, we have already taken steps on respondent number 6 3 times, Lordship. And Lordship, from respondent number 1 to 5, they are appearing, but they have not filed the affidavit and wakalatnama till now.
You know, the wakalatnama has been filed on last date and affidavit is almost ready.
Yeah, for whom? Yeah, for whom?
No, not from petitioner, for respondent 1 to
1 to
5.
So we'll have to await service report on respondent number 6 for some. Heard Ms. G. Swami, counsel for the petitioner, peruse the office note dated 21/6/2023, await service report on respondent number 6. In the meantime, respondent numbers 1 to 5, represented by Mr. Boya, is granted 3 weeks time to file.
You know, one submission, if I may add, you know, this petition is the maintainability of this petition is under check.
The question of maintainability of the petition will be gone into this stage of admission.
Population.
My please, Lordship, I am appearing on behalf of Kathy Pathak, Lordship. On earlier occasion, Lordship has allowed a pair of the petitioner, Lordship.
What do you want?
Lordship, to delete the name of the engaged counsel, Lordship, from the cause list.
Sorry?
To delete the name of the engaged counsel, Lordship, from the cause list, Lordship.
Your name?
Kathy Pathak.
But that you will issue notice and apply to the registry.
Lordship, his name is shown in the cause list, Lordship.
On the pair of petitioners counsel, this matter stands adjourned for 4 weeks so as to enable input. Undertake the necessary process for withdrawing from this brief.
Item 41.
One Lordship, respondents were directed to file compliance report.
Lordship, no Lordship, here I'm appearing for contempt number 1, my lords. Here the matter pertains to payment of arrears salary for 1 month, my lords, to an amount of 35,000. The respondents had initially sent a proposal, my lords, but that was for the previous financial year. Now on the 1st of June 23, my lords, the respondent number 1 has written to the government for sanctioning of the amount, my lords, arrears salary, my lords, on 1st of June 2023, my lords. Lordship may list the matter after the vacation, my lords. In the meantime, we can pursue from the government and find out whether the sanction. Yes.
Mr. G.J. Sharma, counsel.
I'm providing a copy to the.
Mr. H. Cholia, counsel, appearing in this case on behalf of the respondents, who has produced a copy of the communication dated 1/6/2023 to indicate the steps already initiated for compliance of the court's order, with a further request to post the matter immediately after the reopening of the summer vacation. In view of the prayer made by Mr. Cholia, this matter be posted again after the summer vacation. A copy of the communication dated 1/6/2023 be retained in the record of this.
Item 42.
Please, Manoj. My lords, this was fixed for their reply. It's not on record yet. This is a 466 application, my lords. I'm seeking stay of the winding up proceeding. The entire winding up case is predicated on a DRT order, which was finally decided against me. I'm one of the sureties. My lords, now we have, in the intervening period, we have already preferred a satisfaction of the entire debt before the recovery officer. It's my case that the entire debt stands satisfied. That is pending adjudication before the learned DRT, my lords.
You are the applicant.
I'm the applicant. It's
You are the applicant in the
I'm-
IA.
Yes, my lords. Chota Tingray was the surety, my lords, because it was admitted into a provisional winding up. I'm the sister concern as well as common management, common shareholding, my lords.
Where is the IA? Let us see. Yeah, yeah. So you have not filed your objection.
Your lordship, that was actually what was happened, that since the day of the filing, they are in talk with us regarding the settlement. And that is why I have forget your lordship. So I shall be very sorry for that. But in the meantime, on 1/2/2023, the petition on which they are relying, that the petition is pending before the DRT recovery officer, that has already been dismissed, your lordship, on 1/2/2023. So that may be the case.
But you are not filing any affidavit of
One
objection.
last chance may be given, your lordship. I shall be very sorry for that. Because I was under the situation that there may be some.
No, don't tell us all these things.
I
You are
shall-
under the impression or.
No.
We are not concerned. What do you have
My,
to say?
my lords, my case is this. Yes, law will take its own course before the DRT. The entire ecosystem will be activated, my lords.
But we need
Let it
these
be
facts
finally
on record.
adjudicated. My lords.
We need these facts to be brought on record.
Yes, my lords. Yes.
With the, along with the order.
Yes, my lords.
One last chance, you can choose a
Yes.
date after vacation.
Yes, your lordship.
Heard Mr.
K. Khanna, my lords.
A. Khanna and counsel for the applicant. Also heard Mr. M. Sharma and counsel appearing for the OP stroke company petitioner who prays for 3 weeks further chance as last opportunity to file his objection opposing the prayer made in the IA. On the request of Mr. Sharma, this matter is directed to be listed again on 24th July 2023 as a fixed item. No further adjournment.
No, your lordship. I will not sit for it.
Obliged.
Lordship, the respondent filed the affidavit and the order seemed to have been complied. Lordship, we seek for some time to obtain instruction from the petitioner.
My lord, the compliance has been made much before filing of the contempt petition.
What is the order?
Order was to consider his representation. My lord will kindly see the order is page 9 of the petition, and we have filed an affidavit, my lord, that is at page 31.
We'll close it. Heard Miss, your name, please.
Yes, my lordship.
Sumil, heard counsel for the petitioner. Also heard Mr. P.K. Roy, learned senior counsel assisted by Mr. S. Chakraborty, learned counsel appearing for the respondent. This contempt case has been filed alleging willful disobedience of the order dated 3/11/2022 passed by the learned single judge in WPC number 6817/2022. However, by filing counter affidavit, the respondent has brought a copy of the order dated 21/1/2023 to submit that the order of this court has already been complied with. I peruse the same, taking note of the contents of order dated 21/1/2023. This contempt case stands closed.
Right.
Wait, please, Mr. Lordship.
Order complied with?
Complied, but my claim is rejected, my lord.
Then we come, third Mr. IIT Guwahati counsel for the petition, who submits that although the order of this court has been complied with, yet the claim of his client has been rejected. Mr. R. Hart, and the counsel for the respondent submits that the same would at best give rise to a fresh cause of action. Taking note of the submission made at the bar, this contempt case stands closed.
Obligement.
45.
May please, my lord, office should reveal that the my lord service report is still awaited, my lord.
Pardon, sir,
20%.
Mr. Counsel for the petitioner. Await service report on the sole respondent list accordingly.
46.
May please, your lordship, my lord. In this case, my lord, other respondent are served, but respondent number 5 service report is still awaited, my lord.
Mr. M. Islam, my counsel is present on the petitioner. Await service report on respondent number 5.
May we oblige your lordship.
Item 47.
May I please, your worship?
Yes.
In this matter, I am appearing for respondent. Order has already been complied with.
No, lordship.
Mr.
I have not received any order.
I will communicate.
Give it to him.
Yes.
Give it to him just now. Give it to him. Show it to him.
Pursuant to the order, you pass by this one before your lordship.
Not order, lordship.
Not,
It is just a letter, lordship.
not your lordship. District Social Welfare has already taken decision, your lordship, regarding the as part the direction of this one, but your lordship. And as part.
Question is, lordship.
On 23 February, your lordship, District Social Welfare wrote a letter to the Child Development Project Officer, your lordship. Thereafter, your lordship, Child Development Officer submitted report, your lordship.
So where is the order of compliance?
The page 18 March 2023. And it was communicated to the advocate concerned of the petitioner, your lordship, before the filing of this contempt petition, your lordship. Point 4 and 5, your lordship. And thereafter, your lordship, District Social Welfare, your lordship, sought clarification from the Child Development Officer, your lordship. Lordship, kindly peruse next page, your lordship.
So the residency of the private respondent was found to be valid. What else is there to be decided in the contempt case?
Before marriage, she was there, lordship.
Oh, forget it. Who's going to go into all these things?
After marriage,
Contempt
lordship,
case.
she already, she
I
name
had
was.
Mr. H. Alamgir, Learned Counsel for the petitioner, also had Mr. K. Mira, Learned Counsel appearing for the
Sole respondent.
sole respondent who has produced a copy of the order
But
dated
Mompi
18.
Das is also there, lordship. She also already still in this village.
18/3/2023.
But Swapna Das is already married and he done it from that. Also, his name is deleted here, lordship.
District Social Welfare Officer Hailakandi also to submit that in terms of the order of this court, necessary verification have already been made and the outcome thereof was also intimated to the counsel for the petitioner. As such, the order of this court has been complied with. Mr. Alamgir, however, submits that his client is not satisfied with the procedure adopted in the matter.
His name is also deleted from total list also, lordship.
Be that as it may, the aforesaid aspect of the matter cannot be adjudicated in a contempt case. Therefore, by granting liberty to the petitioner to assail the communication dated 18/3/2023 by filing fresh petition, if so advised, this contempt case stands closed. By retaining a copy of the communication dated 18/3/2023 on the record of this case.
Item 48.
May I please, as a lordship?
My lord, this is the first time as a motion, my lord, it is
8 weeks. Yeah,
One.
yeah.
Yes.
Item 49.
Contempt petition, my lord, first time, my lord, and
Mr. M.A. Islam, notice 8 weeks.
all right.
Item 51 and 52.
First
Uh,
time,
May I please, as a lordship?
first time.
My lord, this IA has come up, my lord, with a prayer for considering the interim, my lord. A similar batch of petition, my lord, this honorable court has passed an interim order, my lord. So, my lord, as these petitioners are similarly situated, my lord, we have prayed that similar protection may kindly be given, my lord.
Lordship.
Exactly same.
My lord, that in a writ petition, my lord, they did not serve the extra copy to us, my lord, we did not obtain the, my lord, that instruction, my lord, till date. In 50 number, item 51. 52, I have received the instruction, my lord, I am going to file affidavit in this.
My lord, my instruction is that it has been deposited in the office, my lord. Perhaps my senior friend could not get access of the same, my lord. But my lord, the prayer made in our IA, my lord, is, my lord, my lord, the post in wherein, my lord, we are working, that has been directed not to be filled up, my lord. Or without the leave of the court, no appointment should be made. That is,
So what is the order you want?
my lord, the similar order, my lord, at page 35 of my interlocutory application.
My lord, it's,
What's time to seek instruction? First day, how can we pass that order? Heard Mr. A.R. Bhuyal, counsel for the petitioner. Applicant also heard Mr. J. Henry, learned SC, Revenue Department Assam, as well as Mrs. S. Burwa, learned Government Advocate Assam. We prayed for 10 days time to obtain instruction and file of objection in this case if so required. Mr. Bhuya, however, submits that he is only seeking a similar order
My lord,
in the line of orders earlier passed by this court
My
on
lord.
similar matters.
my lord.
Be that as it may, taking note of the request made by Mr. Henry, his matter is directly posted again on 17 July.
My lord.
in item 52, my lord, I am going to file an affidavit.
Along with item 52, so as to enable the respondents counsel to obtain instruction file affidavit.
Item 50, there is interim order, my lord.
In item 52, you write so and so for the petitioner, so and so for the respondents. List again on 17 July 2017. 2023. Interim order passed earlier to Contempt.
Obliged.
With your lordship, my lord, as per office number 21/6/2023, the service has been completed. Matter will be listed on admission column.
Heard Miss
Yes, my lordship.
A. Sumil, counsel for the petitioner, peruse the, yeah, also heard Miss M. D. Bora, learned Government Advocate Assam, appearing for respondent number
1 to 4.
Peruse office note dated 21/6/2023, which shows that the respondent number 5 has been served. As such, his matter will be listed for admission after the.
My lord.
Yeah, bless lord.
What else, sir?
54 respondents were directed to seek instructions and file counter affidavit.
Protect some time may be granted, lordship.
Mr. Dr. G. Sharma, counsel for the petitioner is present. On the request of Mr. C.
C. Sharma for respondent number 1 to 5, lordship.
This matter stands so as to enable some more time to obtain instruction and file affidavit.
And
List accordingly.
date may be fixed in this matter because man has been allowed to retire prematurely, lordship.
List again on 11th August.